pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you. City Planner, would you please do the roll call?
Good evening. Chairperson Rosales.
Present.
Vice Chair Balma.
Present.
Busk.
Here.
Commissioner Custer.
Here.
Commissioner Crahill.
Here.
And Commissioner Goodkind indicated she would be absent tonight. You do have 6 members and a quorum. All the members are in the chambers tonight.
Thank you. Do we have any, first item on the agenda, communications on matters not on the agenda. Do we have any requests to speak from the public on anything not on tonight's agenda?
There were no requests to speak on non-agenda items tonight.
Great, thank you. Then we'll move to item 3, which is approval of minutes from our last meeting, August 10th. Any input from commissioners? Otherwise, I will look for a motion to approve the minutes. We have a motion. A second? Second. And a second. Any discussion? Seeing none, we'll consider those minutes approved. Okay, we're getting a little bit of feedback from somebody on the phone. If you're joining us on the phone this evening and you have an item you'd like to speak to, I'd ask that you please mute your phone until we get to that item. Thank you. We do not have anything listed on tonight's consent calendar or transportation item, but boy, we do have a few things on the public hearings tonight. So we have a busy agenda. We'll start with where we left off at our last meeting, and that is item number 4, which is our first public hearing. It's consideration of a CUP and a waiver of locational requirements for an applicant, Left Coast LLC. I'll open the public hearing. Disclosures, I'll start. I was on the commission last meeting when we listened to a presentation by staff and the applicant. Since then, I've spoken to the applicant via phone. I believe we've got some emails and some other information. That's my disclosure. Commissioner Morrissey?
Just reviewed what we went over last meeting and saw some emails, but I think we're going to get them read tonight. So,
Great, thank you. Commissioner Custer?
I read the materials, read the emails, drove by the site, and I watched the video of the meeting 2 weeks ago where y'all discussed it.
Great, thank you. Vice Chair Balma?
Pretty much here last session and reviewed the more current emails and voicemails that were sent to us.
Commissioner Busk?
The same as Commissioner Balma.
And Commissioner Crahill?
I had a conversation with the applicant since our last meeting, and nothing else to disclose.
Great, thank you. With that, we'll turn it over to Stephanie Cervantes, planner with the city. Stephanie?
Good evening, Commissioners. My name is Stephanie Cervantes, and I will be presenting the conditional use permit for Left Coast and the waiver of locational criteria that was continued from August 10th. As previously mentioned, the project site is near Oceanside Boulevard on Ordway. The project site is zone limited industrial and has a general plan designation of light industrial. The site is surrounded by limited industrial to the east, north, and west, and residential to the south. The project is requesting approval of a conditional use permit and waiver of locational requirements to operate a medical cannabis manufacturing facility. The project would divide the existing building, and Left Coast would occupy about 6,400 square feet in the southern portion. The existing building is being used for steel fabrication, and Left Coast would build out the interior to meet state and local requirements to operate a manufacturing facility. The business is not allowed direct on-site sales to the public. On August 10th, the Planning Commission voted 6-0 to continue the item and requested additional information. Regarding the CCR prohibition, Left Coast submitted their CUP application on August 27, 2019. On February 26, 2020, the association contacted the city. The amendment has a recordation date of February 10th, 2020. Mr. Alty, on behalf of the association, submitted a letter on August 21st, which states that while Section 8.2 of the association's CC&Rs prohibit marijuana businesses, it also states that the board of directors may grant written exception to the prohibition. The applicant has stated that they will work directly with the association to remedy the issue. Regarding greenhouse emissions, staff had previously determined that the project meets the CEQA exemption criteria. That determination has not changed. The project has no obligation to do a further GHG assessment, and the project does not trigger any of the criteria that was approved by City Council on August 5th. The applicant has provided revised plans that were included in your package and were posted online. And Left Coast has an active local license that was renewed by the city manager's office for 2020. As of noon today, city staff has received a total of 80 comments, 45 in opposition and 35 in support. On August 10th, there was 2 voicemails that were mistakenly not played. On further analysis, staff determined that one of those voicemails was from an individual that had also submitted written comments to be read to the commission. However, the other voicemail from Jeff Horsfield will be played for you now.
Hi, my name is Jeff Horsfield. I'm the Association Manager for the Oceanside Gateway Business Park Master Association. I'm calling regarding Agenda Item 4, CUP 19-00020, taking place on May 18th, 2020. I'm calling to express opposition to this project for a couple of reasons. Left Coast LLC has already been found breaking state and city laws. From the inception to receiving a notice for the CUP application, they have given us no information. Only after the association passed a CC&R amendment prohibiting marijuana did they try to contact us. Shortly afterwards, they began threatening lawsuits. They also approached the association's ownership, claiming that they were given approval by the association. This has never been true. We have never made any agreements or negotiations with Left Coast LLC. Prior to their inception, it was understood that this is something that would not actually take place at 1629 Ordway, and the city has records that we've shared with them showing this in email correspondence. We, as an association, not only passed rules, but a CC&R amendment prohibiting any type of marijuana-related use at the property. It did pass and was recorded and is formally a part of the Oceanside Gateway Business Park Master Association CC&Rs. We do carry a provision in our CC&R amendment and governing documents for negotiation regarding to this particular marijuana-related use. However, we have not been met with any negotiation attempts or any positive communication from Left Coast LLC. We have only been left with threats of litigation and misinformation being spread to our ownership regarding the content of their CUP and situation. Thank you. That is all. Hi, my name is Jeff Horsfield.
At this time, staff recommends the Planning Commission confirm issuance of a CEQA exemption and recommend approval of conditional use permit 19-00020 and waiver of locational criteria. Thank you. I am available for questions, and the applicant is also available via conference call, prepared to give a presentation to address the commissioner's questions from August 10th.
Thank you. Any questions for Stephanie? Vice Chair Bama?
I have a couple. What safeguards within the resolution are there in case the business park owners have a way to come back if something goes awry? Like, I mean, is it like is there a limit to the CUP? Is there city inspections? I know there was some of that we talked about last week, but I'd like to can you just brush over what safeguards are in place right now to make sure that if we do approve this, that there's something for these business owners, which are many, that are very much opposed?
Vice Chair Balma, Commissioners. Right now, the municipal code requires inspections of these facilities. Staff is working on coming to council for fee inspections in the near future, but these facilities will be inspected annually. There'll be a site inspection as well as a financial audit of all the facilities. As part of the inspections, one of the things that will be looked at that's of great concern is odors. The municipal code does not allow any exterior odors from these facilities, so that is something that will be inspected on an annual basis. We also have our code enforcement department as well as a cannabis email and direct line where people can call to report any issues with odor or other similar impacts regarding these facilities that will be addressed at that time.
Mr. Chairman, if I could elaborate, also, as was mentioned at the last meeting, these cannabis businesses have to have a business license that's renewed or reviewed and potentially renewed or not renewed on an annual basis.
Thank you. Any additional questions for staff?
There is no time limit on the CUP, though. Once we approve, it stays in place.
If the Chair and Commissioners, if the CUP is implemented, so they have 2 years to implement it, if the CUP is implemented, then we have to revoke it before it is voided. But if it's not implemented, if they haven't done substantial progress in their business, then it never becomes implemented or valid. So if it is a valid CUP, then we would have to rely on the business license.
Commissioner Morrissey, you had a question?
Yeah, I just want to confirm that this use is not allowed by the CCRs, and the CCRs, the board of directors, have they made a change of mind, or are they sticking to their original decision?
Commissioner Morrissey, Commissioners, the association is still of the same position that the CCNRs prohibit the use. However, the applicant has stated that they are willing to work with the association to address those issues. The city, we have determined that we cannot enforce the CCNRs. That would be up to the association to enforce those.
Thank you.
Mr. Chairman, if I could elaborate on that as well. The applicant's attorney submitted a letter that clearly states that the prohibition is not an absolute prohibition. There's an exemption that can be granted by the board itself. So the board can allow this type of business within the HOA per the newly revised CCRs. So I think it's important people realize that. That also supports the city's position that we don't enforce CCRs. In this case, there's an exemption on the prohibition. It's up to the board.
Yeah, I was going to make a point about that. So the entitlements have no relationship to the CCNRs. If they get entitlements through us to the city, that's their entitlements to operate under the CUP.
Well, if the HOA doesn't allow it, then that would be a matter between the applicant and the HOA.
Right.
As I mentioned last time, some HOAs or prohibition CCRs can change either through a vote. In this case, again, the board can allow it. Some CCRs are probably not legal. If you have a CCR against an ADU unit, as an example, where the state law says we have to allow an ADU, I think it would be very questionable.
Commissioner Quayle?
And just for clarification, the CCR prohibition on cannabis, the HOA did that after or before the applicant submitted their application?
Commissioner Creel, Commissioners, that was done afterwards. So the CUP application came in August 2019, and the association recorded the amendment in February of 2020.
Thank you.
And Mr. Chairman, to be fair to the applicant on this particular item, they were under the impression that the city did not have a waiver which at first the city did not. And the city then changed the existing regulations to allow a waiver. So at one point, they weren't worried about the application because they thought there was no waiver allowed from sensitive uses such as the church or the residence. But the city changed that. When they found out about the city changing it, then they went to amend their CCRs. I believe that's right chronology, Stephanie?
Okay, any other questions, commissioners? So we have the applicant or the representative on the phone as well, and I think Ms. Cervantes let us know that they too could do a presentation or add to. Applicant, would you like to add to the discussion or do a presentation? Is the applicant on the phone for item number 4? LLC, Left Coast LLC? Okay, we can come back to that. Maybe they have their mics muted. We've already covered the public input. We'll close the public comment portion then. At this point, bring it back for additional deliberation for the commissioners. The only thing that I had a question on, or just a comment more, not really a question, for Ms. Cervantes is last time we talked at length about the applicant's path on getting here to us, that it was a bit clumsy, a little bit bumpy. They were operating without the proper licensing before. To me, that was a larger issue. I think I made a comment about that. And I see that your comment to that is pretty straightforward. They're granted their local license, and it's going to be reviewed on an annual basis. Excuse me. Any other input on that item? Because I know again we spent a lot of time on that last time.
Well, to me, that's very bothersome that they would start operating without the proper approvals and the proper modifications
This is
to
Gina
their site.
Austin. Can you hear me? I'm not sure about the delay here.
Yes, we can, Ms. Austin. Can we? We'll finish up with a comment by Commissioner Custer real quick, and then we'll come to you. Can you? Is that fine with you? Okay, good.
Can the commission hear me?
We can hear you. Yes.
Yes, this is Gina Austin. This is Gina Austin. Can the commission hear me?
We can hear you. Yes.
Stephanie, I can hear you, but I cannot. Can you hear me? Can the commission hear me?
Gina, we can hear you.
There seems to be a delay. Commissioner,
Should I call back in?
she doesn't seem like she can hear me. Go ahead, Stephanie.
Gina, if you can hear me, try disconnecting and connecting back in.
I'm on the line, and I can hear him. Hello?
Hello? Ms. Austin, can you hear us?
Do we have Verizon? We have Verizon service here?
We're not muted.
This is.
Ask her if she can hear us now.
There, I turned it up a little bit.
Gina Austin, can you hear me at this time, commissioners?
We can hear you. Can you hear us okay? I think she can hear us. It was just a pretty big delay.
I cannot hear you through the phone. I can only hear you through the live stream, so that there might be a very large delay.
Okay, if you can hear us and you want to go ahead and do your presentation, please go ahead. We'll wait until we can hear you.
I can only hear you through the live stream, which is delayed by about 30 seconds or more.
Please go ahead and do your presentation then, if you can hear us. Go ahead and we'll wait for you to start. I'll give a thumbs up.
You are no longer muted. Hello, this is Gina Austin. I can hear everybody now, a little bit.
Oh, good.
I'm going to assume that you can hear me.
Yes, go ahead with your presentation.
Perfect. Thank you very much. I'm sorry about that technological confusion. Obviously, my name is Gina Austin, and I'm on the line along with the applicants Alex Clementis and Colton Verity and Left Coast lead manufacturer and equipment specialist McLean Metering. And what I wanted to do is present some additional information in response to the questions that were asked by the commission at the last hearing. I believe Ms. Cervantes has a PowerPoint which has 4 slides on it that she can show, I hope. If not, then I'll refer you to some of the materials I submitted regarding starting with the association and those related issues. Ms. Cervantes, are you able to show that first slide?
Ms. Austin, yes.
Mr. Chairman, you may need to repeat it. Sometimes they can't hear the podium as well.
Yes, we have your first slide up. Go ahead.
Okay, thank you very much. So this slide reflects the association property, and the buildings who have voiced support for the project are in yellow. And the buildings that are vacant currently are in purple. And so there was a question at the last hearing about how many owners had voted for the amendment. And we've been doing our best to try and figure that out because we don't believe it was properly noticed. We've been able from tax records to find out that there are 97 different APNs in this association. And the problem is the CCNRs show about 27. And of those 97, the commission has received letters from 15 owners in opposition. So there are 80-some owners who have not voiced in opposition. We do not know whether or not they voted for the amendment because the association hasn't been forthcoming. The purpose of this slide is just to give the commission a sense of what is really going on with the association. The building in green is the applicant's proposed location. Notice that every building around that on that side of the street is in yellow, so they are in support and have submitted a letter in support. Notice that the next closest complex is primarily vacant or has some support. And then the furthest buildings away, we also have a lot of support. So what's important here is to understand the timeline. And in March of 2018, Left Coast notified the association of the proposed use and received no response. So contrary to the comments that you heard in the public testimony today that was replayed from last session, Left Coast received no response, and they reached out again and received no response. In May of 2019, Left Coast received its local license. So it had its local license in May of 2019, and the notice about this project was posted on the property in October of 2019. But it's not until the end of January, more than 8 months after Left Coast received its local license, that the association alleges that it amended its CCNRs. And it did so to restrict a variety of uses that are not allowed in the zone, like slaughterhouses and jails, and then also purports to ban medical cannabis use. So what the applicant is saying is the applicant doesn't believe the association did this properly. But we've been reaching out to the association. We've been trying to communicate with them. There's an ability for them to, if it is valid, for them to amend it. And even as recently as last week, when we reached out to the association again to say, what can we do to make you happy, they refused to meet with us. I think they wanted this process to go through first. So because of that, we're at a situation now where the association is a civil issue. It's between, the two applicants. But it isn't a situation where this graphic is showing you. It isn't a situation where you've got the majority of the people in opposition to this project. You've got a few very loud people who are in opposition to the project, but they haven't provided the commission with a single piece of evidence as to how or why these would violate the findings that are required to be made. Next slide, Stephanie, please. So on slide 2, which is this next slide, this talks about the environmental information, and this goes to the questions that were asked regarding the GHG, the greenhouse gases, and the air pollution control district. We do have our technical person on the phone if you had questions, but there's currently no equipment that is going to be used in phase 1. Immediately, as soon as they would get a certificate of occupancy, there wouldn't be machinery that's being used. They are going to identify some machinery that they would use in the future. When they did so, they would be required to go through the APCD permitting process and get all required permits that would be required to be obtained, and a failure to do so would be a violation of both the local license and the CUP. And at that point in time, the city would then come in and issue a violation or revoke the local license or arguably revoke the CUP. So the applicant has put so much money and time into this. They have every intention of moving forward in the most compliant manner. I think Ms. Stephanie provided the information on the greenhouse gas policy. This is internal. It's not new construction, so it doesn't fall into the GHG emissions guidelines. So no additional studies have been done on that. The next question that I have on my notes from the last hearing, next slide, please, Stephanie. The next question that I have on my notes was the violation, the prior violation. And what I'd like to do is provide some context for you, all to understand how it happened, what occurred. And while this isn't necessarily a land use determination, it does go to the human factor of the applicant, and they are good actors. And my hope is that by providing this information to you, you'll have a better understanding of who they are. So this slide shows that, as you all know, the City of Oceanside has a two-step process. It has the commercial cannabis business license and the conditional use permit process. The applicant received their commercial cannabis business license, and when they did that, they immediately started the process of going through both the state and CUP process. And when they started that process, it creates confusion between the different licensing agencies. So you've got multiple people involved in this pie. The City of Oceanside is number one, because without the city's approval, none of the other agencies are going to allow this operation to occur. The problem is the disconnect between Oceanside and the state, not just Oceanside, but every jurisdiction in California and the state. So next slide, please, Stephanie. The state will issue a cannabis permit. A CDPH, which governs manufacturing, will issue a permit as soon as the local license is issued. The state does not care whether or not you're operational. The state doesn't look into whether or not there's other entitlements that are required. As soon as you get your local license, the state issues the license to operate, whether or not you can do it or not, because in this case we have a CUP. The disconnect occurs because the state assumes that you're operational, and you can't be operational. And the state hires another third-party vendor to do the track and trace software applications. So in this instance, what happened was Oceanside said, yes, you can proceed. The license application went into the state. Sometimes it takes 6 weeks, sometimes it takes 6 months. In this instance, it took 6 weeks. The state said you can proceed, and then this third-party vendor, Metric, gets involved, and that's track and trace. And Metric starts sending emails and says, you must be, they assume you're operational, and they said, if you're operational, you have to have everything in track and trace. They didn't even say yeah. They just say, you need to have everything in track and trace and in the Metric system, or you're going to lose your license. And that's where the disconnect occurred. That's where the problem occurred, because the Metric folks were telling Left Coast they must operate, and the state says you're allowed to operate, and the city of Oceanside said you need to get your CUP first. So what happened? When Left Coast was told that they must operate, or they must, actually they were told they must enter the information into Metric, but they didn't have anything to put in Metric, so they ordered the minimum amount of tags and inventory to put the information into Metric. Then they made one batch of product. They entered everything into Metric. They sent it out for testing. They distributed it to 9 separate state licensed retail facilities. There was no extraction of raw plant material. No machinery was used. Everything was entered into Metric. And that is what triggered the CDPH to come do an inspection. They said, hey, they're actually moving product. Now we're going to do our standard process and go out and view the facility. So they went out to view the facility, and of course, there were violations because Left Coast could not have done the improvements that are required in order to be operational. They were required to separate the other non-cannabis facility with a wall. They're required to put up cameras. They're required to put commercial grade locks on the doors. They're required to have areas that are limited access. And those can't be done until the building permits are issued, and building permits can't be issued until after the CUP is issued. So the state issued a violation, and the license is currently listed as inactive. It's not revoked. They could have revoked it, they didn't. And when we presented this information to the city, and the city got a greater understanding of the good faith of the applicant, of how this confusion occurred between the different agencies, the city's local license was renewed for another year. And so now we're at a point where we only have the issue of the CUP. State violations can't be corrected until the building permits are issued, and at that point the state will come back out and re-inspect and determine that everything is consistent and as it should be, and this operation will be generating revenue and income for the city. So while this information on the state licensing, I mean, it doesn't really lead to any one of the particular findings for the CUP, we felt that it was important to give you an understanding of who the applicants are, and I hope that this information has answered all of your questions as to what happened historically, who's in favor and against the project, and myself and the applicants are on the line for questions. But as I understand it, you'll direct them to me, and if there's anybody that needs to answer, then I can make them talk so we don't have more confusion over the technology. Thank you very much for your time.
Thank you. Any questions for the applicant? And I can repeat those if you have any. Applicant, I don't see any questions from commissioners. Thank you. Well, at this point, I think we will bring it back for discussion and consideration. We've done all the other steps. Commissioner Busk?
I'll lead the discussion if that's okay. First, I'd like to thank staff for addressing and basically curing all of my questions from the last go-around. I thought they were good questions. They needed to be answered. It looks to me like what this poor applicant has been caught in is a regulatory startup issue between the state, county, and local governments. They should not have to be caught in that. It shouldn't have a negative impact on their business, I don't think. I think Commissioner Crayall had it exactly right, that this is the type of location, maybe not the specific one, but the type of location where we would like to see these kinds of businesses. It's in a business park. It's away from the coast. And the other comment I'd like to just say is that apparently our greenhouse gas regulation has a little hole in it. because it says we don't do anything with greenhouse gases if it's not new construction. And while that's the way the rule reads now, and that's, I think, what we need to take into account for our ruling, I think we need to relay that to City Council, because there could be a refurbishing of some building that would have a tremendous GHG impact on our city, and we have no regulatory way to address that as a use. So with that said, and with the additional information that we have this evening, and understanding that CC&Rs are civil matters, not legislative matters, we can't address those. This go-around, I support this application.
Great, thank you. Anybody else? Any other input? Commissioner Kusker, you started
Yes.
something earlier. Go ahead.
Well, I'll just say that she addressed my concern, which was the violation, and it sounds reasonable that the explanation seems reasonable, so that answers that question for me, and concern.
Great, thank you. Vice Chair Bama.
Thank you. And that was a great presentation from Gina Austin. Thank you so much for clarifying all that, because that was one of our concerns last time, was why this all happened. And I can tell exactly from what you shared with us that it's a fiasco, and we understand your pain and suffering. So that was very nice. Thank you very much for that. And also on the other issues of the business park, you sound like you've been doing everything possible to try and work with the business park. And possibly this is a new use in the business park, and people don't, when something's new and it's different, it's changed, it's always going to be hard for people to understand and accept it. So possibly over time, these guys will work a little bit more closely with you, and everything will be a symbiotic relationship. I mean, I kind of think that I feel like at first I thought something wasn't happening there, but it sounds like they just thought possibly the CUP would have held you back as far as the regulations were, that you had to be 1,000 feet away from a school. That the association might have thought that everything was okay because we don't have to worry about this. So that's probably why they didn't jump in and change their CC&Rs right away. But then when they found out that that wasn't going to hold them back, that they jumped in and changed their CC&Rs. So I think that Left Coast has made a great effort to try to work with the business park. I'm not sure if we can add something in the resolution that states that they need to continue to work with the business park. I'm not sure if that's something we can add, but that would maybe make the business park owners that are in opposition at least feel like they have some way that they have some voice in this going forward. But other than that, I feel that this is I think I would support this project.
Thank you. Yeah, and I appreciate and like to commend the applicant on addressing the items, in particular the last licensing one, that it's made more clear to me that that was kind of a clumsy catch-22 that you were caught up into, so I appreciate that. That all being said, I don't see any hands up for any other comments, so I think the next step here would be to entertain a motion if somebody would like to make that.
Sure, I'll go ahead and move that we confirm issuance or recommend that we actually do it. Confirm issuance of a Class 1 categorical exemption per CEQA, Article 19, Section 15301, existing facilities, and adopt Planning Commission Resolution Number 2020-P14, recommending City Council approval of a conditional use permit 19-00020 and a waiver of locational criteria for proposed medical cannabis manufacturing facility at 1629 Ordway.
Thank you. We have a motion. Can I get a second?
I'll second that.
And we have a second. Any further discussion? Seeing none, by vote of hands, all those in favor say aye.
Aye.
Those in opposition, raise your hand, please.
We'll record that as 5 in favor and 1 against Commissioner Morrissey. The motion passes.
Great, thank you. Congratulations, applicant. Good luck with your project.
Thank you very much. We will sign off now, Commissioners.
Thank you. Moving to the next item, item 5, put on my glasses, is a consideration of a tentative map and development plan to allow for the construction of a 6-unit condominium residential development on a 0.32 acre vacant site. The applicant is Hillcrest Villas North and South. James Meng is the actual applicant. I will ask for disclosures. Swing to my right. Commissioner Crahill.
I have nothing to disclose.
No disclosures. Commissioner Busk.
I visited the site, I read all the materials, and while I was doing my site visit, actually the neighbor came out and had a nice conversation with me.
Oh, great. Vice Chair Obama.
Just a staff report.
Commissioner Custer.
I went to the site and read the report.
And Commissioner Morrissey.
Google mapped the site and read the report.
And I Google mapped it and I visited it, and then I got a number of staff supporting documents. And Ms. Chen, if you would walk us through a presentation, welcome.
Good evening, Chairperson Rosales, Planning Commissioners. I'm Tiffany Chen with the Planning Division. Before you are the proposed Hillcrest Villas North and South projects. The two project sites are located near the intersection of Poplar Road and Hillcrest Place. The Hillcrest Villas North site is located at the northeast corner of Hillcrest Place and Poplar Road, and the south site is located at the southeast corner of Acacia Avenue and Poplar Road. Both are in the RH, high-density residential zone with a land use designation of high-density residential and are undeveloped vacant lots. Surrounding land uses include a mix of single and multifamily development, as well as public and semi-public uses. First, we'll go over the North project. Here are some views of the Hillcrest Villas North site. The western portion of the lot is relatively flat, with the land sloping down towards the east. The request is for a tentative map and a development plan for a 6-unit condominium development on a vacant 0.32 acre lot. It would range between 2 and 3 stories and include 2 one-bedroom, 1.5 bath units, 3 2-bedroom, 2.5 bath units, and 1 3-bedroom, 3-bath unit. The first level garage would be accessed from Poplar Road. It should be noted that the garage was originally proposed off of Hillcrest Place. Here's the site plan. You can see the garage driveway that is accessed from Poplar Road on the south side of the building. Here's the second floor plan, which shows a common courtyard area and the location of the 6 units. And here's the roof plan that shows the varying roof elements and not all one roof structure. Here are the elevation views, which show the proposed materials and massing from each side. And here are renderings showing an aerial view and a 3D perspective. Moving on to Hillcrest Villa South, here are some views of the site. There's a gradual downslope towards the southwest corner of the property. The request is for a tentative map, development plan, and a conditional use permit for a 12-unit condominium development on a 0.42 acre site. It would include a range of 2 and 3 stories as well, and include 8 2-bedroom, 2.5 bath units, 3 3-bedroom, 3.5 bath units, and 1 3-bedroom, 2.5 bath unit. Parking is accessed from the alley. The CUP is required to exceed base density for the RH zone and allow up to the maximum potential density of 28.9 units per acre, which is equivalent to 12 units on this property. Here's the site plan. Parking is accessed from the alley to the east, and there's also a proposed driveway to the garage entrance at the south side of the building. Here's the second floor plan, which shows a central common courtyard area and the location of the 12 units. Similar to the north design, the roof plan shows multiple roof elements over each unit. Here are the elevation views with the same style and materials as the north project. And here are the renderings showing an aerial and a 3D perspective. In terms of general plan land use compliance, the projects would provide housing opportunities for homeownership, add to the variety of housing in the area, contribute to the city's RENA allocation housing stock, and is consistent with the RH zoning. The architecture is in the Spanish colonial vernacular and consists of varied roof lines, heights, facade articulation, and a variety of materials and finishes. The project meets or exceeds the development standards for the RH zone, including being a few feet below the maximum permitted height and providing the required parking, including on-site guest parking. In terms of CEQA, staff has determined that both projects qualify for an infill exemption because they are consistent with the general plan and zoning regulations. They are each located on a site that is less than 5 acres and surrounded by developed properties. The sites have no value as habitat for sensitive species. Approval would not result in any significant effects relating to traffic, noise, air quality, or water quality, and they can be adequately served by all required utilities and public services. For community outreach, the applicant held an outreach meeting at the Boys and Girls Club in June 2017. 4 individuals were noted on a sign-in sheet, all residents on HILLCREST Place. Concerns were mainly regarding the lack of available street parking on HILLCREST Place and the original driveway accessed from HILLCREST Place. The applicant also had a separate meeting with the owners of the property adjacent to the North project, where they discussed minimizing the scale of the north side of the building in addition to the parking concerns. In response to the public hearing notice, there was 1 voicemail of opposition, 1 instance of general support, and 1 letter in support. The main concerns were parking along HILLCREST Place and the opinion that the city is already overdeveloped. I'll read one of the comments during the public comments portion. Staff recommends that the Planning Commission by motion confirm issuance of Class 32 categorical exemptions per CEQA, Article 19, Section 15332 for infill development projects for both the HILLCREST Villas North and South projects, and adopt Planning Commission Resolution number 2020-P23 approving tentative map T17-6 and development plan D17-9 for HILLCREST Villas North, and adopt Planning Commission Resolution number 2020-P24 approving tentative map T17-7, development plan D17-11, and conditional use permit CUP 17-11 for HILLCREST Villas South, with the findings and conditions of approval attached therein. This concludes my presentation. I believe the applicant is on the line. Thank you.
Great. Before we go to the applicant, any questions for Ms. Chen? Commissioners? Seeing none, applicant on this item, HILLCREST Villas North and South, can you hear us okay? And if so, would you like to do a presentation?
Hi, this is Alan Hugh with Trey Architecture. Can you hear me?
Yes, we can.
Hi there. I wanted to thank the commissioners for your time this evening. On behalf of Dr. Jim Main, the applicant, and our design team, we want to thank you for your consideration of our 2 projects. This Spanish colonial inspired architecture complements the surrounding area quite well and greatly enhances the appearance of the existing empty parcels. Throughout the process, we have met with neighbors and received positive feedback, and we've also addressed quite a few of their comments. We're here for any kind of questions from the commissioners, and again, thank you for your time.
Thank you. Any questions for the applicant's representative? Commissioner Buss, go ahead.
Yeah, good evening. I have one question on the the 6-unit condo project. I don't see that project requires any shoring, yet that's the project that falls down into that quite steep little valley. I'm assuming when I look at the prints that instead of shoring, you will just be building a very tall foundation wall at the, I guess that would be the northeast corner of the building. Is that true?
Did you hear that question, applicant?
That is correct, Commissioner.
And about how tall is that particular wall? Do you have an idea?
Did you hear that question? There was a question about how tall that wall would be, that supporting wall, foundation wall for that corner of the development.
I do not know offhand. I could look at
Miles Cooper from CEA. The wall is approximately 8 feet tall. It goes from the contour 212 up to 220, around basement elevation. Just under 8 feet.
That's what it looked like from the prints. Thank you.
Okay, thank you. Any other questions? Don't see any other questions, applicants, so this is a public hearing. I'll turn it back to Ms. Chen and see if we have any public that would like to have some input. Any recordings or anything that you'd like to read?
There is one letter that has been requested to be read aloud.
Okay.
My husband and I have owned the house next to the proposed Hillcrest Villas North for almost 30 years and have lived in it very happily for more than 20 years. We love the ocean breezes, the canyon view, and the quiet neighborhood. As a journalist who has covered land use issues, I know the proposed project is part of what Oceanside needs: more well-designed, denser housing. Hillcrest Villas will change our quality of life dramatically, overlook our home, encroach on our quiet canyon, and shade our solar panels. But we support the project as a beneficial change for the community. We appreciate the modifications the architect has made in response to our concerns, moving the vehicle entrance to Poplar, creating some space between the two north units to allow the possibility of some sun will still reach our rooftop solar panels, and making the walls of the top decks partially brick as a gesture to our privacy. We have spent years picking up the trash that blows onto the empty lot in an effort to improve the neighborhood, and a well-managed residential development should resolve that. One of our main concerns is how the substantial fill needed to build the eastern units will affect us. Due to the shape of the lot, the toe of the fill will spread into the canyon immediately in front of our canyon-facing deck, which is where we spend most of our time. We request that the developer give us input on the kind of wall or fence that separates the property from ours. A sound barrier might help a little for the year of loud construction work happening 5 feet from our vegetable garden. A more aesthetic barrier down the canyon might help the radical transition from the manicured landscape on the filled slope and the wilderness garden we have built that currently harbors all sorts of animals and birds. Our home with its canyon deck has been a refuge during the years we commuted to work, and we always dreamed it would be a great place to retire. We have both recently partially retired, and we hope that this development will ultimately improve rather than destroy that dream. In our view, 6 units is too many for this lot, and 4 would be more reasonable. And that was from Allison and Damian Inglis.
Great,
that
thank
live
you.
adjacent to the north side.
Thank you. Any other items you'd like to read or any other input?
That was it.
That was it, okay. Then we'll close the public input portion of the hearing and bring it back to the commission for any additional questions, either for staff or for the applicant. Commissioner Busk, I see your hand sort of raised.
I have a few more.
Okay.
Mostly for staff. Have we ever heard of this YIMBA law firm before? It was an email that came in just before I left the house. A law firm that sent us a note to say, please approve this, and they reminded us of our state law.
Yeah, Chair and Commissioners, we've heard of them. They're not a local organization, but essentially their argument was that there's laws that are recently passed and not so recently passed that, I guess I'll paraphrase, bind the hands of the Planning Commission in terms of housing applications. If you want more detail, or I'll punt to Barbara.
No, that's fine. It was just a new firm for me, so I didn't know if they had a specific agenda on this case or if it was just a general email that they're sending out to all planning commissioners all over the state.
I believe they're a statewide organization, and again, they're, in my opinion, their agenda is pro-housing.
Yeah, that's what it sounded like. A couple of things for staff. In case 8, which we're going to hear later on this evening, we require rodent proofing of large buildings of this size, and yet I don't see that for either of these buildings. Is there any reason for not requiring these to be rodent proofed? Especially the 6 unit, which is right next to that valley, which will have a lot of wildlife in it.
Commissioner Busk, I assume that might be part of the building code requirements, but I'd have to verify that.
I think it behooves us to check that and make sure so that the applicant is not caught by surprise. In fact, I'd like to put that in our conditions because it really, at least that building should be rodent-proof for sure. That was one. And then the second one, it's just a general information, power lines on Poplar Street. I know we require power lines to be built, to be buried. High-tension power lines get exempt from that. Those don't look high-tension to me, so they will be buried?
I believe that, Commissioner Basque, I believe the engineering division did include a condition to underground the utilities on site.
The conditions are in here, but they're not always applied to telephone lines or power lines that are far off the ground and carry a lot of power. Those are far off the ground, but they don't, to me, appear to be carrying the 440 whatever power cutoff. So that was my question.
Chair and Commissioners, the city has an ordinance that requires undergrounding at certain unit counts, and I forget what the trigger is, but I believe both of these would trigger the undergrounding of existing lines. There is a distinction between small voltage lines and higher voltage lines, and I may not be describing that distinction accurately, but I think the point's made. I'm not sure if the lines in this area would be subject to our ordinance or not. Tiffany, do you know?
I believe engineering did include those conditions to underground for both projects.
So we'll anticipate that they will be underground. Mm-hmm. Okay. I ran out of things to talk about. Thank you.
Okay, well, we'll throw it to somebody else. Anybody else have any input or comments? Don't see any hands whipping up, so.
Just a really brief comment that the one public comment that we got, I thought was really well thought out, and, you know, coming from somebody who's an indomitable member of our community as a public news reporter was a nice, refreshing perspective.
Yeah.
I do have
It
one
was
last.
good to hear that the applicant worked with that neighbor who'd been there a long time to work out some of the things that make it a little bit easier to accept this new development, so good to hear.
One last small comment. For that 8-foot tall wall, and I know the applicant is listening, I'm not good enough with plants to know how big the plants are on the plant palette, which is along that wall, but I would hope that the plant palette would include tall plants so that the neighbor did not have to look at an 8-foot tall piece of cement.
Yeah. Good point. Okay. I don't see one last call for comments, anything, any hands. So like the last item, I'll entertain a motion for consideration or motion for anything on this item. Vice Chair Obama.
All right, I'll go for this long one. I also want to commend the applicant for working with the neighbors. I thought that was a great letter we received from the neighbor next door, so that kind of made you feel good. I'd like to make a motion that we consider a tentative map, T17-00006, and development plan D17-0009 for the construction of a 6-unit condominium project at the northeast corner of HILLCREST Place and Poplar Road, and consideration of a tentative map T17-00007, development map D17-0011, and conditional use permit CUP 17-00011 for the construction of a 12-unit residential condominium project at the southeast corner of Poplar Road and Acacia Avenue, with all the findings and considerations attached.
Boy, that was a mouthful. Thank you for that motion.
I'll second that, but can I add a friendly amendment, which is that we add to the conditions at one under, I think it's engineering, let's see. It would be under building, which says rodent proofing, annular spaces around pipes, electric cables, conduits, and other openings in sole bottom plates and exterior walls shall be protected against the passage of rodents by closing such openings with cement mortar, concrete masonry, or a similar method acceptable to the city building inspector. That's.
So we have a motion and then a second that includes some requested amended language to the motion. Is that acceptable to the motioner?
Yeah, so you're just taking the existing motion and just tweaking a word? Is that what you're doing?
Yes.
Okay. I mean, as long as the applicant feels it's reasonable, I don't have any problem with it.
Commissioner Buss, could you help staff understand the revision that you're proposing? I'm sorry.
It's, if you look at agenda number 8, on page, where'd it go? On page 8 of the ordinance, number 9, called rodent proofing. Page 8.9.
So, planning commissioners, this was a little unusual application. There's technically 2 resolutions that you're voting on.
And I
So-
would add that to both resolutions.
So the resolution you referred to is the second resolution.
No, both of them.
On the second resolution, it's condition number 9 on page 8.
He's
On
referring to
agenda?
agenda item
It's
number
a
8.
new item for both of these cases.
Okay, agenda item 8.
You find it in agenda number 8,
Language in the
the
resolution on
language in
page
the
8.
resolution.
It's in another one of
Okay.
these.
So it's language dealing with rodent proofing that's found in a different resolution that we haven't tackled just yet.
Okay, got it.
Okay, thank you.
That's why I couldn't find it.
So now that I'm with you, it's item number 8, and the page was,
Item 8, resolution on page 8, and it's listed as bullet point number 9 on that page, or item 9.
like that language inserted into both the resolutions before you right now.
Correct,
Okay, thank you.
yes.
Okay, I'll ask the applicant if they're okay with that change. Did you hear all of that exchange, applicant? We're adding language referring to the need to secure the property in a very broad sense against rodent, I'll call it invasions of the property. Standard language found in a resolution that we were referring to.
Maybe we should read him the number 9 here.
Yeah, just read it to him, Tom.
Can you hear us okay, applicant?
Yes,
we
are fine with that status.
Would you like me to read it? It's about 4 sentences, or 4.
Yes, please.
Okay. So it reads, rodent proofing, annular spaces around pipes, electrical cables, conduits, and other openings in sole bottom plates at exterior walls shall be protected against the passage of rodents by closing such openings with cement mortar, concrete masonry, or a similar method acceptable to the city building inspector.
Thank you.
Okay? Okay, so we have a motion and a second. We're including language found in a separate resolution that addresses rodent, the building against rodent invasions, again, my term. Any other further discussion before we vote? Seeing none, by a vote of hands, all those in favor of the motion and second? All those opposed, please raise your hand.
There's 6 in favor, 0 against. The motion passes as revised.
Thank you. Okay, moving on to item number 6. Item 6 is consideration of a regular coastal permit and variance to allow an existing single-family residence located at 1709 to enclose a second-story mezzanine, resulting in exceeding the 2-story height limit and allowing an exterior glass railing. Again, this project site's at 1709 South Pacific Street in the South Oceanside neighborhood planning area. The applicant is Dan Matlock and Candace Cross. We'll start with disclosures. Commissioner Morrissey.
Read the materials and familiar with the site.
Thank you. Commissioner Custer.
I read the materials and looked at the site and met with the applicant.
Vice Chair Bama.
Very familiar with this project. Been to the site several times, and I basically was on the commission when we approved the addition of this mezzanine and the conditions of what we put on this applicant. So.
Okay, thank you. Commissioner Busk?
I visited the site. I was also on the commission when this was approved with this mezzanine. Read a bunch of material. I did not read the thumb drive that we were all sent, simply because I've done that in the past. The thumb drive was infected with a virus, a hard-coded virus that could not be picked up by a virus protect scheme. It stole my information, my credit card information, and it took me 6 months to get it squared away. So, but I did read all of the hard copy of material that was supplied by the applicant.
Commissioner Crahill.
Similar, being on the commission before, I had visited the site then, and I corresponded briefly with the applicant this time.
I read a bunch of material, spoke briefly on the phone with the applicant, visited the site, and like Commissioner Busk, I got the flash drive. Actually, tried it in my work PC today, and there was, because I mean, who cares about that one, right? And it didn't. There were no files on it. It never read anything, so I couldn't look at anything. So those are it. Sergio, welcome. You want to walk us through a presentation?
Chair Rosales, members of the Planning Commission. My name is Sergio Madera. I'm a principal planner with the Planning Division. I'm here tonight to present the item for Veronica Moronis, who couldn't be here tonight. She's the project planner who's worked on the application. The project before you includes a request for a regular coastal permit as the site is located within the appeal jurisdiction of the local coastal program area, and a variance to allow for a third story where a two-story maximum limit exists. These applications are regular coastal permit RC 1913 and variance 19.5. Situated within the South Oceanside neighborhood planning area, the project site is located at 1709 South Pacific Street on a beachfront lot. The site has a general plan land use designation of single-family detached residential and a local coastal plan designation of low-density residential. The zoning designation for the project site is single-family residential, or otherwise known as R1. Surrounding land uses include single-family residential to the east and south, a vacant property adjacent to the north, and the Pacific Ocean to the west. The project site is located within the appeal jurisdiction of the coastal zone, and as such, any final action by the city may be appealed to the California Coastal Commission. The project site is currently developed with a 5,574 square foot, two-story over basement single-family residence. The second story of the existing residence includes a second story mezzanine level of 402 square feet. This table represents the permit history of the project site. Project site. The residence was initially constructed in 2004 when the Planning Division was reviewing development in this zone against the 1992 zoning ordinance. Several subsequent applications between 2007 and 2014 were submitted for various changes to the single-family residence, including a request for a third story that was eventually withdrawn by the applicant. After the withdrawal of the 2014 third story application, a new application for an addition, remodel, and mezzanine was submitted and subsequently approved. According to the applicant, during this period of time, the former Development Services Department staff member encouraged the applicant to submit for a variance application to obtain a third story. However, it should be noted that no current staff member directed the applicant to submit for a variance application with the implication that it would be approved. The project site is currently subject to code enforcement action. In October 2019, code enforcement opened a case at the site for unpermitted construction following receipt of a complaint for glass railing constructed on the flat roof at the second story mezzanine level, along with a sliding glass door installed. The complainant also alleged that the second story mezzanine had been infilled, thus creating a prohibited third story. However, during inspection by city staff, the mezzanine open area was not enclosed. After city staff discussion and inspection of the project site, an application to permit the exterior glass railing and infill the mezzanine level was submitted, which is before you this evening. The discretionary application is the action taken by the property owner to abate the open code enforcement case. The proposed project involves the addition of 242 square feet to infill the open airspace at the second-story mezzanine level, resulting in a third story, as well as the permitting of already constructed glass railing to create a 312 square foot deck. The table above breaks down existing and proposed total floor area of the residence. Values in bold indicate that the proposed areas of addition. Exterior deck change and non-compliance with LCP stepping modifications proposed are shown in this slide. The yellow highlighted area is the existing flat roof. As previously mentioned, a code enforcement case is active because the glass railing shown on the right was already installed without the proper city permits. The permitting of the glass railing on the area shown as the flat roof is inconsistent with past precedent to require dwellings to step back from the stream line to ensure consistency with the local coastal program. Therefore, the proposed project is inconsistent with this local coastal program policy. Interior modifications proposed include 242 square feet of infill at the existing second-level mezzanine to create a fully enclosed third story. The zoning ordinance does not include a definition of mezzanine, so staff relied on the 2019 Building Code's definition of mezzanine. Based on the 2019 Building Code definition, the proposed infill will no longer qualify the area as a mezzanine and would instead be consistent with the city's zoning ordinance definition of story. The applicant contends that there is loss of habitable space from not enclosing the airspace. However, the habitable area to be gained is approximately 4% of the residence's existing habitable area. Enclosing this open airspace would provide access to the exterior flat roof the applicant proposes to enclose to create a deck. This slide depicts the area of the residence that is considered basement subject to the city's definition. The blue line demarcates the first and second stories. The area in green shows the proposed third story. It is important to note that the city's zoning ordinance provides separate definitions for basement and story. In an effort to clarify the story limits seen in certain residential zones, Administrative Policy 2012-1 was created. As a result, a basement as defined in Article 3 of the zoning ordinance can exist below a story and not count toward the story limit imposed by the zoning ordinance. This application allows for a multi-level building with the terracing effect. The infill of the open airspace at the second level mezzanine would constitute a third story and is inconsistent with the general plan, zoning ordinance, and Administrative Policy 2012-1. Here is the same basement exhibit showing the southern elevation. The applicant states existing topographical circumstances of the site represent a special circumstance. The project site is sloped as shown above, which is typical of the westward side of Pacific Street. Therefore, the topography of the site does not constitute a special circumstance that deprives the property of privileges enjoyed by other property in the vicinity under identical zoning, under the identical zoning classification. The applicant also notes the lack of initial eastward excavation at the time of initial construction represents a special circumstance because eastward excavation was not warranted at the time. As mentioned earlier, at the time of initial construction of the residence, the 1992 zoning ordinance was applied. The 92 zoning ordinance prescribed a 27-foot height limit or 2 stories, which is less, or whatever is less, which is more restrictive than the current limit of 35 feet. Therefore, the project site would have been subject to a more restrictive standard at the time of initial construction. 15 properties listed by the applicant, including the project site, were reviewed by staff. Staff also reviewed 3 additional properties in the general vicinity that exhibited similar level count, for a total of 18 property histories reviewed. Attachment 3 to the staff report provides additional information. Of the 18 properties reviewed, 6 were granted variances to exceed the height standard for their zone. Of those 6, 5 were approved 30 or more years ago. Only 1 resident since 1990 received an approval to exceed the height of the zone, which occurred in 2011. 11 of the 12 remaining properties appear to comply with the height requirements based on records found and reviewed by city staff. 1 of the 12 properties appears to be existing non-conforming, with a 3rd story granted during the building permit process in 2006. Out of the 18 properties, 7 properties were developed consistent with the 2-story limit over basement. In conclusion, the 18 property histories show consistency on staff recommendation to conform to the zoning ordinance's 2-story limit. For the reasons outlined in this presentation and paralleled in written staff report, the proposed project is not consistent with the city's general plan, zoning ordinance, and local coastal plan. The general plan and local coastal plan outline policies of consistency with city requirements, specifically the zoning ordinance, to ensure compatibility within the coastal zone. As a result of these inconsistencies, staff cannot meet the findings required for the requested coastal permit and variance. Therefore, staff recommends that the Planning Commission, by motion, deny the request for a regular coastal permit and variance by adopting Resolution 2020-P22 with findings attached therein. That concludes staff's presentation, and I'm available for any questions that you might have. The applicant also intends to make a presentation to rebut this evening via the phone.
Thank you. Before we get to the applicant, any questions for staff? Don't see any. Thank you, Sergio. So we'll turn to the applicant. Applicant or the representative is on the phone, I would imagine. Do we have a presentation or PowerPoint that we... Okay. Applicant, can you hear us okay? Okay. It looks like we're going to start your video as your... yeah, right?
Chair Rosales, yes, they've asked that this video be played. I'm not sure if it includes narration. The applicant and their representatives are available on the phone.
Okay, if there's no narration, how would you like to handle this, applicant? We have your video ready to play.
You were asking to play the video initially and then proceed with comments from Catherine Baker, the applicant, and then myself, Alex Maniscalco, as attorney for the applicant.
Okay, that's fine. We'll go ahead and start the video then. Okay, applicant, we've concluded the video, and now you would like to do a presentation. Go ahead.
Good evening, Chair, Commissioners, and staff. My name is Catherine Baker, and I'm the architect for the applicant. The proposed project has been submitted for variance to allow for a residence with 3 stories over a basement. Currently, the existing house consists of 2 stories over 1 basement with a mezzanine level that is open to the 2nd floor. The project proposes to fill in the existing mezzanine floor. This change has no effect on the existing building envelope as it was approved in 2017. The step backs on the existing west side of the building were deemed consistent with the local coastal program at that time. The only exterior modification to the building is the addition of a glass railing where an existing roof is changed to a roof deck on the upper level. The same visual plane of that roof remains and the enclosed portion of the house remains unchanged. The reason that this is coming forward for a variance is that when the property owners originally designed their house, they were required to adhere to a zoning ordinance that was created in 1992. This code was never approved by the California Coastal Commission, which means that the previous 1986 code was still in effect. It allows for a greater height limit and a 2-story over 2-basement structure. The owners were robbed of this opportunity at the outset of their design and are currently not able to comply with the 2-basement rule. If they had been directed to use the correct 1986 code, they would have been afforded the opportunity to design their house as other property owners have been able to do. At this time, I'd like to introduce counsel for the applicant, Alex Maniscalco.
First, I would like to thank staff for their time and consideration of the application, even though we differ with their conclusion, and also thank the commissioners for their time and consideration this evening. This application, first, has been in process prior to the code enforcement matter, notwithstanding staff's comments, and has been discussed at length with staff and on-site inspection, again, prior to any enforcement. After the applicant, we'd like to touch a brief bit of history. As we recall, 2 years ago, we were before this planning commission seeking the approval of Dan and Candace's application for remodel of their home. That application reflected years of prior effort with unsuccessful applications. City staff and ourselves, Dan and Candace's counsel, suggested they trim their application down to the ministerial of right scope of an application to move forward and build accordingly. Staff speculated separately that they would oppose any variance, just as they had opposed other variances like the ultimate. There was no collusion, no promise of favors, and nothing untoward. Staff was matter of fact, saying that Dan and Candace could always return for another permit on its own terms. And this makes sense. It highlights the difference between what's different, between what is permissible of right versus what requires a variance and includes discretion. Put simply, impressed their home under the incorrect 1992 standards in 2007, and then having their remodeling plans denied and opposed from 2014 through 2016, Dan and Candace had to move forward. And so they separated the ministerial plan from anything discretionary. Redesigned their plans consistent with Planning Commission's instruction at their most recent hearing, and staff. They were and are thankful for the Planning Commission's support, as well as the support of City Council on appeal, and the Coastal Commission on appeal after that. As they concluded construction, they were advised to finish construction and then apply for the additional permit if it was their desire. They did so. Makes no changes to the exterior building envelope, nor to the bulk and scale previously approved, retaining the same step back from the street. For the review, Dan and Candace realized the staff's opposition to the ultimate application was more out of the characteristic opposition of planners to any variances. As exceptions, variances reflect a factual review of the Planning Commission. That's what we call the quasi-judicial capacity. So unlike other applications, variances are uniquely in the hands of the Planning Commission. We ask you to exercise that discretion tonight. Again, proposed changes are small and almost entirely internal. They reflect a modest desire within the step-back design to add additional floor delineation and additional use of otherwise unused outdoor space. Candidly, in other coastal jurisdictions, it's common to only have height limits, not a story limit. And we say that after participating in local coastal plan, land use plan, and general plan deliberations. The consensus is by having both terms, it invites confusion. And the definition of a story is often prone to multiple interpretations. Terms appear to bear out to the coastal residents of South Pacific Street. For example, much of Dan and Candace's home is below Pacific Street. Yet, due to an unadopted policy, those levels below the road are not all considered spaces. There's a precipitous change in grade, or the definitions of daylighting. And the explanation is seen precisely for variance, like in the Altman case. I'd like to briefly touch on the standards. Special circumstances. At California Court of Appeals held in 2000, There is no authority to support that a physical disparity is a precondition for a variance. It doesn't have to be something physical in the land. That's from Craig v. County of Santa Cruz. Special circumstances. It's below Pacific Street, which applies here, and it's unique to these homes on this side of the road, much like the others. It could be the requirement to excavate, which would be cost effective, which would be not be cost effective, just like the others. It could be the application of the 1992 zoning ordinance, the applicant's original design, which affected their making sense. So, the special circumstances need not be limited to physical conditions, even though we have a physical condition as well as other special circumstances. Secondly, harmony with zoning and not being materially detrimental to public health, safety, or welfare, or injurious to property or improvements in the vicinity. First, this does not request a variance from public health, safety, or welfare standards. There's no change in scale. There's no change in setback. There's no change in design, so it's supposed to risk of energy to property improvements in the vicinity. And the property complies with zoning in all other respects, including the other requirement of the height restriction. We're still within the 35-foot height restriction. Now not constitute special purposes. Other homes on South Pacific Street have been granted variances. We're permitted to have this construction without regard to the 2012 policy. And it's being a permit which does not affect the exterior of the home. And like other homeowners, as we've shown you on the video, and as we provided in the administrative record, particularly as itemized in the Altman matter, it does not constitute a special purpose because everybody else has it, because so many of these other homes out there have it. And so we note those homes go without limitation. It included 1701 South Pacific, 1816 South Pacific, 1817 South Pacific, 1823 South Pacific, 1901 South Pacific, 1935 Pacific, 1939 South Pacific. All those two-story homes, or four-story homes, either with variance or without contradictory permitting. Without regard to the basement policy. 1823 South Pacific is actually is one of the most recent approvals, Ms. Altman. And again, staff proposed Ms. Altman's application in the same way. But then, as we've cited and provided, met language reciting how the application meets these requirements. And Danny Candace's application did so exactly with that. One note on the dual basement distinction. We would argue it's an attempt to step around the various requirements. We understand it's an unadopted policy. But somehow it's being used to exclude folks who did not excavate back. With the practical impact that when you look at their homes, they look like four-story homes. By and large, the properties all have four-story level, four-level appearances, and without regard to 2012-1. Final note on local coastal program policy 68. Staff has said that the proposed policy doesn't meet that, and it's non-conforming. However, the August 14, 2017 staff report for this permit looked at the same, which is not changing. Noted the second part of the building was 5 feet and enclosed with 5-foot deck with glass railing, extending the streamline with a decorative roof overhang, providing visual interest and relief. The upper mezzanine level, the third floor we're talking about here, back 10 feet farther with a similar decorative roof overhang. Overall, the step back at the upper levels will serve to reduce the apparent bulk structure and meet the city's goals for step backs from the beach. That's RC 16-00014, page 5. So staff went through this exact same silhouette, this exact same step back, and said it met that coastal policy. Again, we referred to the Altman variance in the examples, the resolutions, and we can respect that verbatim if you like, certainly, but we provided that in the record. I'd like to conclude with a couple notes. And Candace's changes their mind, and they don't change the exterior profile or the bulk and scale. It increased floor area by about 242 square feet. Today, in the post-COVID environment, that floor area is more important when people spend more time working and staying in their homes. So, Yeah, we would ask for a little more sensitivity, with regard to these kind of permits now. Second, we provided farmlanders from up front on 60 acres on South Pacific, 2 on North Pacific on the strand, and 3 in Oceanside, inland of to support, and have been indexed and provided to you tonight.
Thank you. Does that conclude your presentation?
And we respectfully request your approval and are happy to answer any questions you have.
Okay, thank you. Any questions for the applicant at this point? Yeah, it looks like there's a question for you. Go ahead, Vice Chair Balma.
Yes, thank you. That was a lengthy presentation. Thank you so much for all that great information. I have one question for the applicant. I know I was on the commission when we went through this back in 2017, and I know that mezzanine at the time was very controversial, and we ourselves had to figure out how that was even allowed. But after the end result was, we voted to approve it, and it went on to the, as you know, the appeal, and it was still approved. But I want to know, why did the applicant, after all of that, decide now to add a glass railing and a sliding glass door and put in a floor when the approval was for a mezzanine? So what made the applicant want to go to the next level and pretty much push the envelope?
Well, I apologize, there's a little bit of echo, but I believe the question was, the applicant was approved for the mezzanine, which we believe was a contentious approval at the time. And after being granted that application, why would they be here now for these permits, basically filling in the infill and the glass railing? Did I hear it correctly?
That's right.
Well, for 2 reasons. First, the third story, the completion of the fill-in of the mezzanine would no longer be basically a extension of the second story. It would become a third story. And I think, as everyone from that hearing may recall, the mezzanine was limited to a third of the area of the floor below. I believe I'm saying it, getting a nod from me. Architect, thank you. And so when they did the application, staff's response, in crafting the application, and that weighs very heavily with an applicant, right? Particularly if you've been through several iterations and failed. Staff's response was, well, that's discretionary, and we're not sure we'd approve that. And while it wasn't before then, we got the strong inclination that they would oppose it. And so by linking the entire application and jamming up the approval at that time for this area, it was a big risk and a big ask for our client to take. And so they moved forward with an upright application. And so now we can sit before you and say, here, we were fairly granted an upright application, we would say. And with that, she was extended to the discretionary area. And while it is an expensive exercise for our client, it basically shows very clearly the delta between the two, right? It shows how far we're able to go upright, and then what truly requires the discretionary variance approval. And that now would lead, the substantial part of construction done, they can come back to you and to have a practical discussion of the scope, but without worrying about the bulk and scale, because we're not changing the exterior. Without worrying about the overall design question. It's more of a personal question about its internal configuration of rooms inside of a home. And so I would submit all those points. We are thankful to have received permits and to have constructed. But I think the intention and the discussion with that was to, practically, and the city attorney can explain, to consider what's called exhaustion of the remedies and putting together applications that reflect what's right and what's discretionary and different standards of review for all of them.
So I kind of hope, before you keep going on and on, so what I'm gathering is that you're saying that city staff must have suggested in some way that you could go ahead and fill in the floor and add the railing and the sliding glass window, and then along the way you can probably apply for a variance and it'll be okay? Is that why you, I can't understand why someone would do that after we went through such a dog and pony show back in 2017 to get you the mezzanine, and then you do all of this, and now here we are. I mean, did someone tell you to go ahead and do this? Is that what you're saying?
Sorry, no, I was not saying that they were told to fill in without a permit. To the contrary.
Okay, maybe we can come back to that point. Maybe we can articulate that in a different way. Any other questions from commissioners for the applicant? Seeing none. Again, this is a public hearing, and so we're looking to Sergio for any written or perhaps recorded input from the public.
Chair Rosales, Planning Commissioners, we do have a host of written correspondence that was requested to be read into the record. We also have 2 voice messages to be read or to be listened or played into the record.
How many written requests do we have?
It's approximately 15.
City Planner, can I ask for your input on, are we limiting, are we doing 3 minutes for those writtens, or however long we have, or how are we proceeding with the written input?
Under the special procedures for COVID, we are limiting public testimony that is read or played to 2 minutes each.
Okay.
And that's been noticed, and that's been consistent for several meetings now.
Great, thank you. Go ahead, Sergio.
Okay. Having been a neighbor to the property at 1709 South Pacific Street years before the lot was developed as a single-family residence by current owners, I observed over time there has been an obsession by the owners to increase their structure to monolithic proportions. To my knowledge, the applicants have claimed special circumstances in the variance applications, which has no basis. To grant the variance to Matlack Cross would be inconsistent with Articles 41 of the Oceanside Certified Zoning Ordinances and, in my opinion, negatively impact neighboring properties. Therefore, I respectively request that you deny the Matlack Cross application. Thank you for your service to our Oceanside community. Carol Kaler, 1637 South Pacific Street. Dear Honorable Planning Commissioners, applicants have said the opposition to their after-the-fact variance is a neighbor dispute. On the contrary, it is a community attempt to prevent the success of substantial, flagrant, and designed coastal permit code violations, and to reveal the applicant's attempt to minimize the awareness of the adverse effects their actions have on the financial and aesthetic character of this coastal community. In an email to city officials, Council said it best: applicants have not only embarked on a public relations campaign to spin their transgressions as victimhood, they are also seeking to create a perception that others should follow their lead and do the same with their properties. Rather than comply with the directive of code enforcement in response to their flagrant violations within 2 weeks, the applicants lawyered up and filed for a variance. Not until 48 days after being made aware of the violations did the code enforcement finally find time to inspect the illegal construction. By that time, applicants had removed unpermitted flooring, but had done nothing to comply with the earlier order to timely remove the unpermitted patio deck. This code enforcement action should have remedied the situation prior to allowing applicants to undertake the current permitting process. These clandestine improvements, enclosing the mezzanine and constructing the patio, were part of the applicant's earlier submittals, but had been removed when staff made it clear that they would not be allowable. Indeed, by endorsing an after-the-fact permitting process at all for recalcitrant applicants who knowingly and superstitiously flaunted legal requirements, the city has essentially enforced a permitting framework that undermines its own codes and penalizes neighbors who actually seek to follow the law. We support the just posted staff recommendation to deny the variance. Variance is site-specific and after-the-fact request doesn't meet the necessary requirements. Respectfully submitted, Mr. Thor A. Stensrud, 1705 South Pacific Street. Dear Honorable Planning Commissioners, after careful review of the thorough staff report, I find no evidence to support granting this variance to the applicants. There are no conditions that dictate this couple requires yet another floor and illegal deck in their already grossly oversized home, 5,574 square feet, the largest on the beach. They have displayed continued disregard for building codes and laws, and instead have proceeded with a confidence and nonchalance that flaunts their belief that they are above the law and should get whatever they want regardless of rules and negative impacts to their neighborhood. The existing building codes must be enforced and respected in order to preserve the character of the waterfront community. Please do not let a precedent be set that rewards greed, lawlessness, and deceit. I applaud the staff recommendation to deny this variance and strongly encourage you to uphold the recommendation. Respectfully yours, Whitney Stensrud, 1705 South Pacific Street. In reference to the permit RC 1913 and variance 19.5, I wish the city would approve their request that has gone on for entirely too long. Their home and their project has improved all of our properties in a positive way. This has gone on way too long and has been wasteful in the city's resources. Thank you. Annette McDonald, 1639 South Pacific Street. I and my ex-wife Carol have the right to live in our house at 1637 South Pacific Street. However, we issued a living trust to our 3 children that by some means of the law has put our children in charge of the house. Big mistake of 20 plus years ago on my part in trusting my oldest son, Kipton. Therefore, the children claim they own and control the house, although Carol and I have 100% paid for the house and the taxes, all the upkeep, and day-to-day utility expenses. However, Carol now lives in Omaha, Nebraska, and I am at the house once a month due to the fact that I moved my business to Nevada. This background is important because our youngest son, Teague, who is now living for free at the house, plus my ex-wife Carol and former friend Tor Stensrud, is against the above permit and variance. I disagree with the position of my son Teague has taken on the issue of the permit and variance. I support the changes and believe Dan and Candy should get their permit and variance based on the law of permits and variances for the city of Oceanside as determined by staff and the legal foundation of Oceanside. Personal disputes are carried too far because there is too much money to do so. The beautiful sunsets, the wonders of nature on the ocean, and happiness that could be is all overshadowed by this, fighting. No one spends millions for property, pays outrageous taxes to live in a community of unrest. This has to end. It is tearing up the neighborhood and certainly not helping my dysfunctional family. Best regards, Gary Kaler, 1637 South Pacific Street. Dear Chairperson Rosales, Vice Chairperson Balma, and Honorable Planning Commissioners, the staff report you have just heard provides a thorough and thoughtful analysis of this application, and I commend staff for their work. The facts provided in the staff report make clear is that the applicant is asking you to grant a variance to forgive their blatant, willful violation of Coastal Permit RC 16-4, which this commission approved just 3 years ago. This is not the applicant's first attempt to seek approval for a third-story addition. The applicant initially sought a variance for this in 2014. That variance application was withdrawn by the applicant in 2015 when it became clear that it could not be supported. The long review process for the addition to this property, which began in 2014 and ended in 2017, thoroughly addressed the issue of third story and ultimately included the approval of a mezzanine level. It is noted that the mezzanine was originally proposed to be 630 square feet in size, but was required to be reduced to 400 square feet to comply with the California Building Code definition of mezzanine level. The simple question you should consider is this: what has changed since the Commission's last action related to the issue? The answer is that nothing has changed except that the applicant got caught with their hands in the pickle jar. The applicant obviously knew that what they wanted, a third story, had been rejected before, so they attempted to secretly build a third story in violation of the 2017 coastal permit and with complete disregard of the requirements of the zoning ordinance, the California Building Code, the city's LCP, and the California Coastal Act. A cynical person might strongly suspect that the applicant intended all along to build out the mezzanine into a third floor and was just waiting for everyone to look the other way. Now they want you to say that it's okay. For the sake of maintaining the integrity of the discretionary review process, you should not buy the applicant's attempts to justify their corrupt actions by making false equivalents and misleading comparisons to other properties, and by claiming that a city building official told them it would be okay to ignore your prior determination and the conditions of their coastal permit. You should ask yourself what precedent should be set if this commission approves a variance based on the facts you've been presented, the circumstances related to this application, and against the thoroughly researched and well-considered recommendation of staff. Respectfully submitted, Larry Taylor, 301 Mission Avenue. We, Gregory and Don Swazian, have been homeowners in Oceanside since 1990. We have reviewed a description and justification of the Matlack Cross residential project and fully support their proposed changes. We have been in the residence and can attest to the well-appointed, high-quality interior and exterior features. The proposed changes to the residence is an upgrade to one of the finest homes in the neighborhood located in the city of Oceanside. Cordially, Greg and Don Swazian, 1825 South Pacific Street. Dear Planning Commission, we own the property at 1711 South Pacific Street, next door to Don Matlack and Candy Cross at 1709 South Pacific Street, the property which you will be discussing. We have read over the changes that our neighbors want to make, and we have no objections to their plans. We feel that granting their application will not be detrimental to our property. Further, we feel that their request is consistent with other properties and can only improve the area. We have known Dan Matlack and Candy Cross for almost 20 years. During that time, we have watched with enthusiasm the improvements that they've made to their home. We feel fortunate to own the home next door to such warm, caring, kind neighbors that care about their neighborhood. Audrey Smith and Jan Cipolla, 1711 South Pacific Street. We, Larry and Christine Rowe, have been homeowners in Oceanside since 1988. We have reviewed a description and justification of the Matlack Cross residential project and fully support their proposed changes. The proposed changes to the residence are an upgrade to one of the finest homes in the neighborhood located in the city of Oceanside. Their home has improved all of the properties in that neighborhood. Their request has lagged on for way too long. This needs to be resolved to allow them to move forward in their enjoyment of their home. Thank you for your attention in this matter, Larry and Christine Rowe. I understand the Matlack Cross home at 1709 South Pacific Street is on your agenda this evening. When I was on City Council in 2017, I walked around the property to get an idea of how this home fit into the neighborhood. It was obvious any approved remodel would complement homes on both sides. Tonight you'll decide whether or not to allow some work on the interior and the exterior. I realize any changes typically raise the ire of others who have already expanded their properties to the maximum allowed. Such protests are predictable and reflect a disturbing "I've got mine, you go away" attitude. I believe the proposed interior changes will make no difference to anyone other than the occupants. The proposed exterior work does not impact adjacent properties and should be approved by the Planning Commission without further evaluation or delay. Thank you for your service to the community and attention to this item. Chuck Lowry, Oceanside. Dear Planning Commissioners, I oppose the granting of variances to Matlack, 1709 South Pacific Street, Oceanside. Please deny this request. The structure is already the largest structure on the block, and the requested variances would increase the bulk even more. Granting these variances will encourage other builders to exceed established limits. I have lived here for over 30 years, and each new structure built is larger than any of the other. Each new structure built is larger than any other on the street, even though they all claim to be following the established codes. Thank you. Rennie Dowling, 1716 South Pacific Street. Dear members of the Planning Commission, we live one block south of the subject property and were asked by the applicants to support this requested variance and also their earlier 2016 coastal permit. We took no position on the 2016 project. Today, we ask that you uphold staff's well-researched and dispassionate recommendation to deny this application. The applicants are requesting a special privilege to exceed the two-story limit imposed by Section 1709 of the city's 1986 zoning ordinance. The project would also require ignoring the Commission's policy for coastal dwellings to be stepped back rather than have a solid slab front. We met both requirements when our own home was approved by the Commission in 2001 and 2007, as have other neighbors before and since. We do not believe one exception in 30 years is precedent that justifies throwing out the zoning ordinance and existing policy. As the pictures show, this massive box is already out of character for our neighborhood. It is the largest single-family residence in the stretch of between Buccaneer and Cassidy. According to Zillow, it's also the most expensive. We ask that you avoid a dangerous precedent and preserve the existing zoning rules by denying the coastal permit and variance. Thank you for your consideration. Joel and Elizabeth West, 1730 South Pacific Street. Honorable Commissioners, thank you for hearing public testimony. 2 points. 1, exemplary staff report. The staff report is an extraordinary repudiation of the applicant's behavior and variance request. Well-researched, well-considered, well-crafted, thorough. I trust the Commissioners will apply similar diligence and deny the Matlack variance. 2, false comparison to the Altman variance. 1709 South Pacific and the Altman residents have little in common. 1709 has maximized the size, bulk, and scale possible under both the 92 and 86 zoning ordinance. 1709 is over 2 standard deviations from the average home size, nearly double the average of all beach homes, and is, right now, the largest home on the beach with epic mass against the string line. In contrast, the Altman residence is a modest 1970s beach cottage with light foundation and shallow basement. Seeking a 462 square foot addition, the Altmans face difficult options without a variance. Although sympathetic, staff applied the law and recommended denial. The Commissioners struggled with the Altman variance. Nuanced and multifaceted, Commissioner Rosales stated the dilemma. We have the intuition that it's a hardship, but we lack the evidence to support it. Page 43, 44. Commissioners, is the applicant subject to a unique hardship? What is your intuition? Support staff's recommendation. Deny the Matlack variance. Thank you. T. Kaler, 1637 South Pacific Street. That concludes the written comments. We do have 2 audio comments to be played into the record.
Sure, go ahead.
Please play this message at the April 24th Planning Commission meeting. This is Marcia Carney, a resident of Oceanside, and I'm calling regarding agenda number 6, the Matlock variance. Please vote to uphold the staff recommendations to deny this variance. Thank you.
Hello, this is Marco Gonzalez with Coast Law Group. I'm calling to leave a message to be played for the Planning Commissioners for the August 24th, 2020 Planning Commission meeting, agenda item number 6. I want to start by telling the Commissioners that we really appreciate staff. I represent a number of residents in the vicinity of this application, and we know that for such a small matter, staff has really had to take quite a bit of time with it. Given the amount of information that was submitted for this variance, we just wanted to say it was a really heavy lifting to come to the correct decision. That being said, we want to support staff's recommendation And as we've submitted in written comments, we want to implore you to take a look at the historical nature of this particular property, in the sense that what they're asking for, they've already asked for twice. They've already been told twice that this would not be a permittable request. And most importantly, they tried to do it anyways. But for the vigilance of the neighbors pointing out that they were building out a fourth story without permits, they would have fully constructed it. And they did actually fully construct a deck on top of a rooftop that they were not allowed to. So when they get up and scream, "Oh, poor me," and they talk about how everyone else is allowed to do it, I'd say let's just look at the staff report. They've done everything they need to show you both that practically and legally there's no reason to support this variance. Thank you for your time, and look forward.
Commissioners, that concludes the public comments received for this item.
Thank you. With that, then we will bring it back for questions to staff, questions of the applicant, comments, whatever your desire is. Any input, Commissioner Crayhill? Looks like you.
I would love to. You're implicated in one of those comments. So for those of you who may have been on the commission at the time of the Altman residence approval, do you have any words to impart upon us that could help us inform our decision here?
Yes, I was on the commission with the Altmans and went to their house to see what it was. And it was a very modest house. It isn't a huge house, but what they wanted was to add that extra story. But they had done a lot of improvements on the front end, like as far as the entrance goes. They kind of addressed the street, which most people just have the wall and the garage door. They actually put in a whole front end that kind of made it more inviting. So that was kind of one of the reasons why I think we thought their design was very sensitive to the neighborhood. They weren't trying to build, setback to string line. They just wanted to just have that one master bedroom. I think it was a master bedroom on the top floor. But they set back. They did the step back design very well. So they did a lot of things that actually addressed the neighborhood, and I don't think they had much negative support at all from any of the neighbors, except for possibly the Matlocks or some of the people that were kind of like fighting for their own thing. But they were pretty much well received, I thought, when we did that. I mean, I know the staff had recommended for us to deny it, but we came back, I think, with a 6-0 on that. I think we actually were all pretty much in agreement that that was a good project. So we went ahead and approved that variance.
Yeah, and I'll just add to it very similar comments. I recall, as with all of these that have come to us over the years, really struggling with the 86 and 92 issue and giving discretionary, ability on a variance and so forth. So it was a struggle. So I think, as Vice Chair Obama put it, with the Altman project, because it, quote unquote, my term only, respected. It was softer, and it respected kind of the feel that if you're going to request a variance, then don't go over the top. That it lodged itself with the Planning Commission at that point, and we felt, I guess, a bit more comfortable pushing that one forward. So, do we have that discretion? I think so, and so I think that's kind of where we landed that night on that one.
They even modified their window designs on one of the floors to address the neighbor next door's concern that they couldn't see through their visibility. So they 45'd one of the windows so that actually the neighbor could actually see better for their view.
Thank you.
Sure. Yeah, Commissioner Custer?
I just want to comment that I think that this, their proposal I would be in favor of approving it because it does not change anything on the outside. The height of the building's already there. The entire build-out's already there. So, from the neighbor's perspective or anyone else in the city, it won't modify what they see at all. So.
Okay. Commissioner Busk?
Yeah, I'll just give a little bit different perspective on that. Since I was on the case when it was approved in 2017, the first time I saw this project, the rebuilding of this particular house project, what we were shown was it was 4 stories tall. It was a solid glass front. There was no articulation on the beach at all. First time we saw it, said, that's not gonna cut it with the way we want to develop the beach. It has to have step back. After a lot of conversation, where we landed on stepping back was what they're now calling the third floor / mezzanine, was to have nothing in front of those glass windows at all. Right now, they've got it enclosed as a glass deck, which puts something in front of that. That means it's not a step back anymore. We had long conversations about what can be on what they're now trying to make into a third floor and what constitutes a mezzanine. We actually went to 2 or 3 different definitions and ended up with a state definition on what constitutes a mezzanine, and that's why they actually had shrunk it in size to where its current size is. They insisted that they had to have the mezzanine. It was a design criteria for the inside of the house. We have to have that mezzanine to make the inside of the house work. There was no talk about enclosing it. There was no talk about putting a floor on it. It was a design criteria for the inside of the house. This application, to me, is an absolute perfect example of an applicant who has design creep built into his previous application. He knew what he was going to do, I think, in the long run. In the short run, he got the mezzanine approved, which means he had to build out the outside of the building, not the deck, but the outside shell. And then, gosh, I can just fill the inside of the shell in, and gosh, I've got a roof all right there. Why don't I just make that a little roof deck? Nobody will mind at all. That's project creep, and it's not acceptable, I don't believe. And I commend staff on their thorough investigation of this particular item, and I certainly support their what they've asked for, which is to deny the variance.
Thank you. Yeah, and I would commend the staff on the research and information they provided. I think there was sort of a tacit suggestion that staff may be leaning one way or the other, but I would look to staff to interpret the policies and regulations and apply them, appropriately, understanding that the commission has some discretion to be able to, modify that or lean a different way. So, again, I appreciate the research that was done with that. So, any other further comments or input, or are we ready to proceed to a motion?
I'd like to make a motion if that's in order.
Certainly.
I move that we adopt a resolution denying a variance, V19 405 and coastal permit RC 19-00013 to allow an existing single-family residence to enclose a second-story mezzanine, resulting in the residence exceeding the 2-story height limit and the installation of exterior glass railing at the proposed third story on an existing flat roof to create a deck at 1709 South Pacific Avenue. Matlock variance. Applicant Dan Matlock and Candace Cross.
Okay, we have a motion. We're going to hang on to that motion before I ask for a second. City Planner, do you have some input? We've been asked by the applicant if they could rebut some of the comments.
Excuse me, I believe it's the protocol to allow the applicant to rebut up to 20 minutes. I believe they still have several minutes left out of their 20.
Sounds good. We have a motion. We haven't taken a second yet, so we'll step out. We'll hold that motion. Applicant, go ahead. How many minutes do we have allowable for rebuttals?
My comment will be fairly brief.
Yeah,
okay,
I
go
don't
ahead
have
then.
an exact number.
Go ahead, sir.
Okay. This is Alex Smith, the attorney for the applicant. First, I must say the comments about the applicant's behavior are hurtful and they're actually untrue. As a code enforcement matter, Mr. Gonzalez's comments are wholly incorrect. There was no allegation of unpermitted construction of the deck. But again, people have been saying that Mr. Matlock and Ms. Cross have enclosed the mezzanine. And that's actually not borne out by the record. When code enforcement came out, the area was open. There was a complaint made that appears to show the interior in a photograph of the interior. However, as the city's own engineering staff can testify, and has actually said in comments back to the complainant, the EGs, or the joists, and the joist hardware, one had been used previously as scaffolding, and will continue to be used as scaffolding to complete installations in the ceiling for ceiling fans, for speakers, for recessed lighting fixtures. And so the mere presence of that and the allegation that there is some sort of untoward attempt or intention to enclose the mezzanine in willful disregard of the city of Oceanside's approval could not be farther from the truth. It's hurtful. Existence of the railing, the applicant has been open. It's an open railing. The applicant has been open about that and has acknowledged that they are concerned about the safety of not having the railing. When they were confronted about the railing, they acknowledged it and evidenced a willingness to take it down if there was a concern, but specifically addressed the safety concern for which it was there, particularly for people cleaning the windows. And then discussed the fact that the fact that the glass is there allows people to see the proposal in this application, which they knew they were being filed. So I don't. It is tremendously hurtful to have to be advising clients to follow the law, see them follow the law, know that the application is in place, have a code enforcement matter that gets called up when everyone's on holiday, me, myself included, visiting my in-laws over Thanksgiving, and that there was some sort of untoward delay, something unusual when our clients consented to search when they didn't have to. They brought everybody in. They wanted to have counsel present, which is their constitutional right. And when they have followed the city's law to a T. So I want to address that clearly, unambiguously. There was no present intent or intention of closing the mezzanine. The mezzanine was not closed in, and staff itself has acknowledged that the joist hardware is there, acknowledging this application, it was there. And that is the only thing in the record, that there is an open void with the joist hardware there. There is no evidence of anything backstage or anything of that nature. I appreciate your time and your consideration.
Thank you very much. Okay, so we have, we've allowed the rebuttal, we've had the public input, we have a motion on the floor by Commissioner Busk. I see a hand raised by Vice Chair Bama.
I would say that I agree with a lot of the comments that this has gone on too long, because it has. And the neighborhood fighting has been something we've been hearing about for years in various forms, and that's kind of a sad thing. Dan and Candace both are wonderful people. I don't think anybody did anything hurtful to them in saying what they're doing. I have nothing against them as human beings. And their property is quality, like a lot of people said in the comments. But what happened with this application, it was kind of like, in a way, like one of the comments was after the fact kind of like design, which was kind of harsh to like believe. I mean, yes, you can fight and say that there was no mezzanine when the picture was taken, but it sure does look like there was something there. I'm an architect. I can see that the evidence there shows some kind of construction. So I'd have to second the motion on this and go back to, this house is still a beautiful home. There's still a lot there that they can enjoy and prosper and love living on the coast without having this one other section filled in. So.
Okay, so we have a motion, we have a second. Any further discussion before we vote? Seeing none, by a vote of hands, all those in favor of the motion, please raise. All those opposed, please raise your hand.
For the record, we'll indicate that it's 5 votes in favor, 1 vote against Commissioner Custer. So the motion passes, which is to deny the variance application.
And just to be clear, the applicant has the opportunity to appeal the decision by the Planning Commission, correct?
That's correct. It's in the coastal zone, so they have 20 days in which to file a petition of appeal.
Okay, thank you. Moving right along, we will take up item 7, which is consideration of a tentative map and development plan, variance and regular coastal permit to allow development of a 16 residential condominium unit located at 1021, 1027, and 1031 South Cleveland Street. The applicant is the Hall Land Company. We'll start with disclosures. Commissioner Crayhill.
I have nothing to disclose.
Commissioner Busk.
I read the material. I'm very familiar with the site. It's on my daily walk.
Vice Chair Bama.
Read the material, Google Earth, and I'm very familiar with the site as Gary Linden's surfboard shop is located in the building.
Nice one. Commissioner Custer.
Read the materials and walked the site.
And Commissioner Morrissey.
Read the materials, Google mapped the site, and familiar with the site.
And my disclosures, I familiar with the site, did a drive-by and read the materials. Mr. Nightingale, good evening, welcome.
Good evening, Chair, Vice Chair, members of the Planning Commission. I'm Scott Nightingale, here to present agenda item number 7 for the consideration of a tenant parcel map, tract map, development plan, variance, and a regular coastal permit to allow the development of 16 residential condominium units over 3 parcels. Here's an image of the site in the blue here. The site is 0.46 acres. It's located at 1021, 1027, 1031 South Cleveland Street within the non-appealable area of the coastal zone. The site is medium density R3, which permits condos, apartments, and single-family type developments. The site is surrounded by other R3 developments pretty much in all directions with the exception of the railroad property directly to the west. The proposed request is a tentative subdivision map to create a one-lot subdivision for condominium purposes, merging the 3 parcels into one legal lot and providing for common interest development comprised of 16 airspace condominium units pursuant to article within the subdivision ordinance. Also, a development plan to demolish the existing structures and to enable the 16 unit condominium development. And also a variance to allow a 5-foot reduction in the standard 15-foot front yard setback along South Cleveland Street for a new front yard setback of 10 feet from the front property line. The deviation from the front yard setback is necessary to provide the city's required additional 5-foot required right-of-way dedication. Cleveland Street was actually developed at 50 feet in entire width, where on the circulation element is supposed to be 60. We've approved numerous variances along all of South Cleveland Street here for this similar request, so they'll be following in suit with that. And lastly, a regular coastal permit just to construct the development because the project is located within the non-appealable district of the coastal zone. Here's some images of the site. The site is comprised of 3 parcels. One parcel being 9,954 square feet, the other one approximately 4,977, the other one pretty much the same. The site is surrounded by other multifamily type developments, like I said in the introduction there. And it exists with a 7,410 square foot commercial building, which was used as a cabinet shop and surfboard manufacture and distribution, with also accessory manufacturing, and a 1,849 square foot residence and a 4,980 square foot vacant lot. Here's an image of the tentative parcel map, which will allow the 3-story, 16 airspace condominium development, which with also various common areas to be managed by the HOA. The proposed density, let me go back here. Proposed density of the project is approximately 35 dwelling units per acre, which is under the 43 dwelling units per acre requirement for the R3. The site will be fully landscaped. The landscaping will not only enhance the neighborhood, but the property as well. As you saw in the photos, we don't really have much perimeter landscaping here, or nor do we have any street trees. So the proposal will now bring in some aesthetically pleasing landscaping, not only along South Cleveland Street, but also along the railroad properties as well, so towards the rear. Here's an image of the floor plan, first level. They're proposing a first level parking garage, access off of South Cleveland Street. Approximately 33 parking spots within the garage. 3 of those will be allocated for guests. 4 of those 33 total stalls will be constructed with level 2 EV charging to meet our climate action plan. They will also provide some bicycle parking and also some storage for the units there. And there's also some, we worked with the applicant to provide some at-grade access to provide more of a pedestrian feel off of South Cleveland. So you have 4 units which will have access from South Cleveland as well. Here's an image of the second floor with 10 units. Third floor, we have some portions that have a second level from that first, and also 6 additional units. Here's an image of the roof plan, which will have a common access stairwell as well as an elevator and some areas for solar panels. Here's an image of the proposed architecture and elevations. They have more of a urban beach contemporary design, which is pretty much inspired by a lot of the developments that were approved all along South Cleveland Street and also Oceanside, the coastal areas. The well-articulated 3-story structure would create an attractive scale and pattern complementary to the existing developments within the area. The elevations are detailed with numerous pop-outs, such as decks, decorative metal railing, fiber cement, laps siding, stucco details, decorative windows, metal awnings, and recessed windows, as well as differences in colors and textures to provide some more additional articulation. As stated in the staff report, the building's parapets and stairwell and elevator rooftop structure have been designed to meet the Oceanside Zoning Ordinance Section 3018 for exceptions to heights. The elevator shaft, as well as portions of the parapets, are also under the 10% threshold of the building's footprint to allow for additional height exceptions. So with that, when analyzing this project, staff reviewed the project based on the following. It achieves a balance of residential uses, is providing additional opportunities for residential housing, provides good transition between the existing high density and the existing single family in the area. The proposed residential use and number of units is compatible and appropriate for the area in terms of density. And in terms of zoning, its project meets the required findings with the exception of the requested variance for the front yard setback, which precedent has been established by approving other dedications. And lastly, it complies with the local coastal program. There'll be no public coastal access impacts. This project is fairly, I would say, 3 streets removed from the west coastal area there. It is also at least a quarter mile from the Sprinter station and less than half a mile from the transit center. There'll also be no public coastal views. It's not in a public coastal view area, nor will there be any public parking impacts. With the development, they're actually going to be providing additional on-site or street parking by creating the curb gutter and sidewalk. So with that, staff recommends that the Planning Commission by motion confirm issuance of the CEQA exemption and adopt Resolution 2020 P25 approving the tentative map development plan, variance, and regular coastal permit for the construction of the 16-unit residential condo complex. This concludes my presentation. I'd be happy to answer any questions. Sean Santa Cruz from the Hall Land Company is also on the line. Thank you.
Thank you. Any questions for Mr. Nightingale?
Not at this time.
I don't see any. The applicant's representative, you're on the call? Or you're available to do a presentation?
Yes, I'm here. Can you hear me?
We can hear you fine. Thank you. Go ahead.
Thank you, Mr. Chairman and Commissioners. My name is Sean Santacruz with Hall Land Company. I'll be brief. Don't really have a formal presentation, but I'd like to take this time to thank Scott Nightingale for his presentation. This project, agenda number 7 and agenda number 8, represent our 5th and 6th projects along Cleveland Street since 2013. And this project is a culmination of sort of the design trends and feedback we're getting from the general public for more variety in bedroom count, elevator access buildings, and also a kind of a combination of stacked flats and townhome units versus the traditional 3-story townhome units. And that's sort of the design that you're seeing in front of you tonight. We had worked with staff closely in making sure that the articulation on the building allowed for not only ground floor access, but created the feeling of a townhome development along the front facade on Cleveland Street to be consistent with other projects that ourselves and other developers have built over the years now along Cleveland Street. And essentially what you see before you is sort of a new concept that we're moving forward with and trying to appease the general marketplace, and also to open up the affordability and purchasability of people that are looking for not just a 3-bedroom townhome unit, but a variety of products in one location. So with that, basically here to answer any questions that the commissioners might have, and that concludes my presentation.
Okay, thank you. Any questions for the applicant? I don't see any, so we'll go to public comments. Scott, do we have anything you'd like to read in or play for us?
There were no voicemails. I did receive 2 calls during the review process from 2 of the neighbors. They were just basically questioning staff's approval of projects in this similar bulk and scale, and asking why we are allowing these types of developments that shadow the existing single-family homes. You guys did receive one of the emails. I can read that if so. It's from Carolyn Kramer.
Yeah, if you would, please.
I can do that, sure. So there was an email received today at 11:12 a.m. This is regarding this item as well as item number 8. South Cleveland condos, this is from Carolyn Kramer. South Cleveland condos, please make this project not look like a wall. Please require articulation and give this some character instead of a wall of stucco and concrete. Oceanside deserves the best. Thank you, Carolyn Kramer, 904 Leonard Avenue, Oceanside, California, 92054.
Okay. Any other written or?
No, that was it.
Oh, okay. So we'll close the public hearing portion, and the only comment I have about that, I think I've said this before, we've seen developments like this happen more and more on Cleveland, and it's the trend, and they're generally, like this one, very attractive. And I think once before I said I made a comment about displacing or overshadowing the single-family homes, which was, what was in place for all those years. And I don't have a question or comment, just kind of an observation that at what point does that not happen, or do we preserve those? And I think this had the ones these are displacing or in that area, there's no historical significance to those, but just a comment or observation that I've said before that, it's a good transition for what used to be there for sure, but I wonder at some point, will that be all we see on Cleveland Street in those surrounding areas, or will we, see some of the smaller, more bungalow 40s and 50s types of homes that are there? So again, just an observation. Any comments or questions, Commissioner Busk?
Yeah, first I'd like to compliment Mr. Nightingale for once again bringing forward a couple of really well thought out projects. I kind of wish I was in the mode to shop for a condo, because I would find one that you helped plan, and I would buy into that particular condo complex. This one something stuck out at me. It was condition 36, where we're requiring a 3-inch PVC conduit for future signal interconnect cable. I don't think I've ever seen that on a project before. It wasn't on the next, it wasn't in the next project. So I was just wondering, is that common, something that the Highway or Engineering Department requires of all projects, or is there something about this project that makes it different from the others that we've seen on Cleveland? Condition 36, line 15, page 13.
Commissioner Busk, I'll have to get back to you on that one. I'm gonna grab it real quick. Sorry.
Okay, we shouldn't be putting, if we don't need to put extra conditions on these developers, we shouldn't be charging them for stuff that they don't need to. It seems like if it needs to be on this project, it should be on the next one as well. So there's just a little inconsistency there, and it was nomenclature I hadn't run into before, so that's why I had the question. Thanks.
Is that it, Commissioner Busk?
Yeah, and I echo your comments that this one is one of those little coastal, has one of those little houses on the lot, and
Yeah.
like how many of those have to go away before Oceanside, as the community says, no mas, that's enough. It looks like Cleveland's all going to be condos by the time we're finished.
Okay, any other, Commissioner Crayhill?
And maybe Scott will be able to get the answer to Commissioner Busk's question, but the signal interconnect cable might have to do with the rail line and signaling for the rail line.
Yeah, but we've never seen it before on any of the, I would think they'd be common on all of Cleveland projects.
For the ones that abut the rail, yeah.
And we haven't seen it at all on any of them yet, so. But it may be just because it abuts the railway. Yeah, good point.
I think you're right. It could have, because of the proximity of the rail, could have something to do with it.
So then it should be on.
That should
in
be
case 8 as
consistent
well.
on similar projects. You're right.
Yeah.
That's correct. It should be on the other one as well, so we should
Clean
add that
that
to
up,
item
okay.
8.
Okay, thank you. Okay, unless there's any further discussion, I'll entertain a motion.
I'll make a motion.
We've got to, go ahead, Commissioner Custer.
Pass a confirm issuance of a Class 32 categorical exemption for infill development projects pursuant to Section 1533-2 of the California Environmental Quality Act, and approve tentative map T20-00002 developmental plan D20-00003, variance V20-00002, and regular coastal permit RC20-00001 by adopting Planning Commission Resolution Number 2020-P25 with findings and conditions of approval attached herein.
Thank you for that motion. Do I hear a second?
I'll second.
And we've got a second, Commissioner Crayhill. Any further discussion before we vote? I don't see any hands raised. So with a motion and a second, all those in favor, please raise your hand. Aye. All those opposed? All those opposed, please raise your hand. I don't see any in opposition, so I think it's unanimous.
So we'll record that as 6 in favor, 0 against, so motion passes.
Thank you. Which takes us to our last public hearing item this evening. Similar applicant, similar project, different entitlement documents, of course. With that limited introduction, I will ask for disclosures. I imagine they're about the same, but we'll go through the process anyway. We'll start on my left. Commissioner Morrissey.
Same as last.
Thank you. Commissioner Custer.
The same.
Same. Vice Chair Bama.
The same, except for the surf shop.
Commissioner Busk.
The same as well.
And Commissioner Crayhill.
Nothing to disclose, same.
And I have similar disclosures as we did on the last one. Mr. Nightingale, item number 2, similar applicant. Go ahead.
Okay, thanks. Scott Nightingale from Planning Department. Here to present item number 8 for the consideration of a tentative map, development plan, variance, and regular coastal permit to allow the development of a 14 unit residential condo development over 3 parcels located at 1105, 1107, and 1109 South Cleveland Street. Here's an image of where the site is located. It's 0.41 acres and is comprised of 3 separate legal lots totaling 17,895 square feet. It's located on the west side of South Cleveland and south of Eucalyptus Street. And it is zoned R3, medium density residential, and it exists with a 2,100 square foot single family residence and a 1,152 square foot commercial building and a vacant parcel. All of the buildings on site do not hold a historical significance per the submitted survey that was part of the attachments. The request, tentative subdivision, to create a one-lot subdivision for condominium purposes, merging the 3 parcels into one, to create the 14 airspace condominium units. Also, a development plan to demolish the existing structures and enable the construction of the condo development. And again, similar to 1021, a variance for a 5-foot reduction in standard 15-foot front yard setback along South Cleveland for a new setback at 10 feet from the front property line. And again, this is for the city dedication 5 feet off of South Cleveland Street. And lastly, a regular coastal permit to construct the 14 condominium units located within a non-appealable area of the coastal zone. So here's an image of the site. The site is located within the non-appealable area. Each lot, like I said in the introduction, they're about 5,000 to 6,000 square feet in size. Site is located in an urbanized area, about a quarter mile, similar to the 1021, quarter mile from the transit center along Oceanside Boulevard and Coast Highway, and about a half mile or less from the Oceanside Transit Center. The site is surrounded by other single-family and multifamily, as you see here in the image. You have the railroad tracks directly to the east, and northeast you have an apartment complex. Here's a view from the west of the commercial facility adjacent to the 1043. Also a former automotive type aviation facility directly to the southeast, adjacent to the site. And a view to the southwest of 1109, a vacant commercial building. Oh, and lastly, the multifamily building. This tentative map will allow the development of a 3-story, 14-unit airspace condo. The proposed landscaping will also provide an ample amount of landscaping that's not really provided as of today. They'll provide new street trees, as well as some rear landscaping, as you'll see from the railroad tracks. The first level parking garage will be located on the first level, on the ground level here, accessed off of a way of South Cleveland Street. This parking garage will provide a total of 29 parking spaces. 26 of those will be designated for the residential units and 3 for guests. Per the Climate Action Plan, they are also providing 4 out of these total spaces that will be situated with EV charging infrastructure for level 2. Second floor will house 9 units, as well as third floor will have some second levels. Oh, yeah. There we go. Second levels from the other portions. 4 of those 9 units on the second will be the second level from the bottom there. 5 other single level 3 2-bedroom units on the second floor, as well as 2 1-bedroom units. The roof plan, similar to 1021, you have a common access stairwell as well as elevator. Similar to 1021, this project will have an urban beach contemporary design, which is similar to many of the new developments along South Cleveland. The proposed 3-story structure would create an attractive scale and pattern with the articulations, variations in color, and material pop-outs and balconies. This project also provides stairwell, elevator parapets, which do exceed the 35-foot height limit, but they're in kind and in compliance with zoning ordinance section 3018 for exceptions of height limits. In total, they're less than 10% of the total building's footprint and are under the 45 height requirement there. We did receive some public testimony. The two callers also were calling in response to this project as well, commenting on the bulk and scale and the shadowing effect of single-family homes. And the email that I just read for item 7 was also applying to this as well. So when we're reviewing this project, staff reviewed the project based on the following. For general plan land use compliance, achieves a well-balanced of residential units. It's well under the required density. It's actually a density that we're looking for, a higher density. Provides a good transition between the existing high density and the single family. Proposed residential units and number of units is compatible with the area and the city's vision. The zoning, it complies with all the zoning ordinance with, except for the exception of the proposed variance based on the 5-foot city dedication. Since it's located in the coastal area, we reviewed it per local coastal program, no public coastal access impacts, nor public coastal views, and no public parking impacts. They're providing new curb and gutter, which will actually provide additional parking along the street. So with that, staff recommends Planning Commission by motion confirm issuance of the CEQA exemption and adopt the resolution 2020 P26 approving the tentative map, development plan, variance, and regular coastal permit for the construction of a 16-unit residential condo complex. This concludes my presentation. I'll be happy to answer any questions. Thanks.
Question for you, Scott, from Vice Chair Bama.
I have a question. Like, I understand why the 5-foot variance is requested and have no issues really with that. But what I was kind of asking was what's happened on Pacific Street with all of the setbacks have kept approaching closer and closer, and now you have like a block face average, and so now there's almost 0 setbacks. Could this ever be used on the other side of Cleveland or any other area where we'd have to? Because I understand the side with the 5-foot for the city dedication, but can this end up using it for what's happened on Pacific Street, which I really never have liked?
I mean, all of them most likely would probably have to go through a variance process, and we would most likely have to honor it because we set the precedence of allowing the 5-foot reduction. And it's on both sides.
That's on both sides of 5-foot? So it's just basically a right-of-way thing that happens on Cleveland, and it won't really migrate other places then, probably.
Yeah, it'll only occur on Cleveland.
Okay,
so.
All right.
Rusk.
Yeah, I'm sorry, Scott, I just can't leave this PVC conduit thing. It says owner developer of the 3 on interconnect cable on all arterial level and above streets. Cleveland is not an arterial street, is it?
I don't believe so. Now, I'm sorry, what condition number is this?
Number 36.
36.
And 36 on the previous case. Sorry, case number 7.
Oh, back to 7. Okay.
I'm back to that one. I'm just obsessed on it. But it's only for arterial level streets. And I don't believe Cleveland's an arterial street.
Perhaps, Scott, we could have you look at that issue for both items and make sure that we're consistent and it's consistently being applied. Would that work for you?
Yeah, I just want to make sure that we get it right.
Sure.
and applied to both, because it's not a railroad requirement, apparently. It's a street requirement of ours for arterial streets, and I don't believe Cleveland's an arterial street.
Okay, yeah, if you could look at that.
I can look in with the traffic director and the
and you'll fix whichever one
engineering and
needs
see
to
what we
be.
can do and see if it even applies, actually.
Thank you.
Yeah.
Any other questions? Or we have the same applicant, so we have them on the phone. Applicant, can you hear us okay? Would you like to do a subsequent presentation, or how would you like to handle this? You have that opportunity.
Yes, Mr. Chairman, it's Sean St. Cruz, Gamma Paul Land Company.
Sure.
I just wanted to point out two things on this one. One is in regards to the right-of-way vacation of Eucalyptus Street. We had worked diligently with staff and NCTD on that. and all were very cooperative and supportive of vacating that portion of the right-of-way. As a result of that, we are doing larger drainage improvements there, where all the water now currently sheet flows over the eucalyptus tree onto the train track. We are now collecting all that water, treating that water, and holding it back, and then releasing it onto the NCT property. So it's going to be a dramatic improvement in the drainage situation at that location. Additionally, the important thing that staff had pointed to us from the very beginning was the Coast Highway View Corridor analysis. And although eucalyptus is designated as a minimal view quality rankings per the report, we were asked to preserve the 20-foot of right-of-way vacation with no buildings or obstructions to preserve as much of the view as possible down eucalyptus from Coast Highway, which is what you're seeing here today, where there's no building or structure encroaching to that 20 feet. It's just used for adjacent parking to serve the development. So I just wanted to point out those two features of the project and how those evolved over time, working with staff and NCT on the project.
That's great. Good to hear that. Sounds like those are good, two good pickups. Any other questions or any questions period for the applicant? I don't see any, so we'll go to the public. City planner, is it appropriate, okay, to, Scott referenced the same public input for number 7 and 8. Do we need to repeat that or just accept it as is?
Scott, unless there's anything different, I think we can just say the prior comments are also applied to this project as well.
Okay.
Absolutely.
Any new ones then, Mr. Nightingale? Or?
No, same comments from
okay.
the previous item.
Okay, then we'll close the public portion, public hearing on this and bring it back to staff. Any last minute thoughts before we entertain a motion? Don't see any, so I'll be glad to entertain a motion from anybody.
Well, I'll make the motion.
Go right ahead, Commissioner
Okay.
Custer.
Confirm issuance of a categorical exemption per CEQA guidelines, Article 19, Section 15332, infill development projects, and approve tentative map T200003, developmental plan D200005, variance V200003, and regular coastal permit RC 20-00002 by adopting Planning Commission Resolution Number 2020-P26 with findings and conditions of approval attached herein.
Okay, we have a motion by Commissioner Custer and a second by Commissioner Morris. See any further discussion? Don't see any, so by raising our hands, all in favor, just raise your hands, aye. All those opposed, raise your hand. I don't see any opposition, so it looks unanimous.
It's 6 in favor, 0 against. Motion passes.
Thank you. Congratulations, applicant. Thank you, Mr. Nightingale, for the presentations. That concludes our public hearings for tonight. I don't see anything on the agenda for either appeal of city planner's determination nor any discussion items, so I think we can proceed to city planner's commissioner reports. I don't have anything to report myself this evening that I can think of. I thank everybody for their input tonight. We had a lot of items on the agenda and we got through it relatively quickly and good comments. Commissioner or Vice Chair Balma?
Well, I don't know if you've read anything on social media right now, but Measure L, they had the lawsuits from Integral that sued the people that got all the signatures for that on the ballot, and the first lawsuit was thrown out. So the developer isn't really doing too good on their lawsuits. So.
One down, one to go.
Pardon?
One down,
one down and one to go, yeah.
Yeah, so it'll likely go to a vote.
Yeah, it will go to vote because the second lawsuit won't come into play till February of
February,
next
yeah.
year. So now, unless they put the pressure on the 3 girls that actually did all the work to pull it off the ballot, which they could still do if they pressure them hard enough, but I don't think they will. They're pretty much going for it, so
Right.
it's
Pretty
going to be
tough
on the
ladies.
ballot.
They're pretty tough ladies.
Yeah, they're pretty tough ladies.
Commissioner Crayhill?
I have nothing to report.
No report. Commissioner Busk?
I just have one comment about this evening's stuff. We approved 48 new units for the city of Oceanside. Not a single unit includes inclusionary housing. And I think that's really too bad. I know they have to pay into in lieu fees, but we all know that it takes forever to get an in lieu fee collected to the point where we actually have a project. So somehow inclusionary has to be included in some of these larger projects. And I don't know how we do that, Mr. Hunt, but it sure would be nice if we could do that.
Chair and
That's it.
Commissioners, the council's actually directed staff to look into changing the inclusionary fee to make it more attractive to build the units on site rather than simply pay the fee. It's just a direction to come back with some information and perhaps a recommendation, but your thoughts are not alone. There's others who share that.
And it seemed like 1 or 2 of these projects this evening would have been perfect to have 1 or 2 units as inclusionary units, and it just didn't happen. So that heartens me. I'm glad that's happening.
Yeah, they all seem like they were in good locations to include something like that. You're right.
Yeah. That's it. Thank you.
Okay. Commissioner Goodkind isn't with us this evening. Commissioner Morrissey
No report.
and Commissioner Custer.
No report.
Okay, we'll throw it over to City Planner. Jeff, what do you have for us tonight?
Your next meeting, September 14th, we're going to cancel it because we have no items. It would have been nice to spread things out a little bit, but life isn't always convenient, so we take it as it comes. Council, the September 9th meeting has the Sunsets 2 project. This is the mixed-use project at Horn and Pierview. And then September 23, we've scheduled the Left Coast project that you heard tonight. Going down to our outdoor business permits, this is the relaxation of regulations to allow outdoor dining and even retail display during COVID. We're up to 70 permits now, so it's been very popular. We're getting a lot of kudos and a lot of appreciation for that. And then finally, the Chambers is scheduled to have the phone line be a direct line into the speaker system, the audio system. That should be complete by your next meeting in September or October. So we'll look forward to having better audio.
Question on that. So then who manages that if something were to go really sideways and we were wanting to mute or cut the person off? How, is that something you'd control or?
I'll ask our IT about the technicalities on how it'll all operate. Yeah, good question.
Okay.
That's all I had.
City Attorney, anything that you want to? Okay. Well, good. Thank you again for all your input, everybody. I think we stand adjourned.